The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. We're happy to hear argument in our first case, Farm Labor Organizing Committee versus Stein. Ms. Granke?
Good morning. May it please the court, my name is Christy Gronke, and I represent the plaintiffs' Farm Labor Organizing Committee, also known as FLOC, and Valentin Alvarado Hernandez, who are the appellants and cross-appellees in this matter. Section 20.5 of North Carolina's 2017 Farm Act profoundly undermines the ability of farm workers to exercise their constitutional and state statutory rights to associate with FLOC, the state's only farm worker union. Section 20.5 imposes unique and highly burdensome restrictions on FLOC. And it's
Can you talk just a tad louder, just a little bit louder?
I'm sorry.
No, it's me, I think.
Section 20.5 profoundly undermines the ability of farm workers to exercise their constitutional and state statutory rights to associate with FLOC, the state's only farm worker union. Section 20.5 imposes unique and highly burdensome restrictions on FLOC and its members' ability to enter into purely optional dues checkoff and settlement agreements. It is designed to gut FLOC's ability to function effectively and thus to suppress its vigorous and often controversial speech and assembly. Section 20.5 violates the First Amendment because it narrowly targets FLOC by outlawing entirely voluntary dues checkoff agreements that are available to all other private sector unions and employees in the state. The leading case here is Minneapolis Star, in which the Supreme Court struck down a tax on paper and ink use that had adversely impacted a small group of newspapers, where the state had failed to demonstrate a special characteristic of the newspapers that were targeted that justified the limited scope of regulation. The Supreme Court recognized that such selectively imposed burdens by their very structure suggest that the government is targeting certain disfavored speakers for burdens, and these burdens can suppress speech. As the court observed in Minneapolis Star, a law that targets a small group of speakers for discriminatory treatment, quote, suggests that the goal of the regulation is not unrelated to suppression of expression, and that such a goal is presumptively unconstitutional, unquote. The severe restrictions imposed by Section 20.5 are extremely targeted. FLOC has been the only farm worker union engaged in collective bargaining in the state for decades, and it is the only union whose activities are impacted by Section 20.5.
Why isn't it more reasonable to conclude that that's a consequence not of North Carolina law, but of the National Labor Relations Act, right? I mean, North Carolina's position is, look, if we could ban this for all unions, we would. But we only can for this category of unions because the NLRA exempts those unions. So why, I mean, I agree, it seems pretty micro-targeted, but what do you say to the proposition that the reason it's micro-targeted is because federal law wouldn't allow it to be anything other?
Well, Your Honor, as we pointed out in the briefs, there are other categories of unions that are not targeted by this law that are exempted from NLRA coverage. So I don't think that really answers the question. And simply because there is a regulatory gap, doesn't mean that the state should fill it in a burdensome and targeted manner.
Can I ask you another question on the dues checkoff provision? So the briefing is a little bit of ships passing in the night because of the disagreement in part about what the provision means. So I understand that you argue that it means the broader thing, but let's assume for the sake of argument that it means the narrower thing, that the district court thought that it meant. And then I see these two cases of ours that say there's no First Amendment right to a dues checkoff provision. And your argument, as I understand it at that point, is that's public versus private. Do you have any other way to distinguish, again, assuming that the narrower construction of the provision is correct, which I know you don't agree with, but assuming that it is, do you have any other way of distinguishing those cases other than the public-private distinction?
You're speaking of the Campbell case, I think, Your Honor.
Yes.
So looking at the Campbell case, something that I think is critical, other than the public-private distinction, which I do think is critical, the question there was what the state was doing as an employer, in its role as an employer. Here, the state is not acting in its role as employer.
I understand that Campbell could, and there's language in it, but there's also just broad language in Campbell that says there is no First Amendment right to have your employer withhold your union dues. There's some pretty broad statements to that effect. What do I do with those?
Well, Your Honor, obviously, there is Campbell, there is certainly a line of cases that say that there's no constitutional right to dues checkoffs. But this is a case about targeting and narrowly targeting one union and one small category of unions, but really one union for nearly insurmountable obstacles to fundraising. And if Your Honor...
What is it about, you say they're nearly insurmountable burdens on fundraising, but isn't that true? I mean, is it any more true in this case than it is in most dues checkoffs? Or is that sort of a...
It is more true in this case, Your
Why?
Honor.
Help me understand why you think that.
Certainly. First of all, it's in the record that dues constitute 50 to 60% of FLOC's budget. And we've talked about who are the members of FLOC. They are H-2A guest workers from Mexico. They come here a few months out of the year. They're living dispersed in rural areas in the state. They're living in employer-furnished housing for the most part. They're not having access. They don't have their own transportation. They are mostly monolingual Spanish speakers. There are many burdens to accessing the means that would allow them to pay dues in other ways.
Okay, so because it's uniquely hard for them to pay their own dues is the argument.
Yes, it's certainly part of the argument, yes, Your Honor. But I would point out that in Minneapolis Star, there is not a requirement that the burden be particularly severe. What matters is the targeting and the threat that the targeting conveys.
Can I ask you then, I know I asked you to ignore the public-private distinction. Could you, again, assuming the narrower reading of the dues checkoff provision, why does the public-private distinction matter?
The public-private distinction matters because of ESRSA, Your Honor, and the Supreme Court's reasoning in those cases that have to do with the state interest in not having to subsidize speech. In other words, the state has more freedom to discriminate against speakers when it is subsidizing the speech. Here, we're not talking about state-subsidized speech.
Wait, I'm sorry. The theory is that the state has more authority to discriminate against speakers than private individuals do?
When they are subsidizing the speech, yes, Your Honor. That's clear from ESRSA.
But a private, there's no First Amendment problem with a private entity subsidizing or making any choices about speech, right? Like, the whole point of the First Amendment doesn't really limit the private actor.
That is true, Your Honor. And before Section 20.5, agricultural producers, employers were free to agree to these checkoff agreements or not. I wanted to, going back to the importance of ESRSA, I would also point out that in Justice Ginsburg's concurrence in ESRSA, she specifically notes that all parties to that case agreed that if the impositions that were at stake in ESRSA were in fact being imposed on private parties, they would violate the Constitution. And I think that's telling because, again, in Campbell, we are discussing the state in its role as subsidizing speech and also as an employer. I do want to go back to a point that Judge Heitens brought up earlier with regard to targeting and the question of the regulatory gap. There is some interesting legislative history here in the form of SB 375, which was earlier legislation that was considered by the General Assembly, which would have outlawed not only dues checkoffs for all unions that aren't covered by the National Labor Relations Act, but also some private organizations, dues for private organizations being deducted from people's paychecks. And indeed, the court, the legislature was unable to pass that law. And then, in a much more targeted form.
I just don't want to run out of time, and
Sure.
I want to talk just for a minute about the settlement provision.
Oh, yes.
There seems to be sort of an assumption here that if we adopted your broader reading, that is that this bars sort of all settlement agreements, not just the subset that is suggested by your colleague, that would be a First Amendment problem. And I'm having a little trouble understanding why, even under the broader reading, there's a First Amendment concern.
So assuming that the statute were being interpreted to apply to all settlement agreements between an agricultural producer and FLOC.
Correct.
Okay, that is a concern, Your Honor, because of the very clear precedent that's actually been recently acknowledged by this court in Capital Industries, which is that as an expressive association, Flock has a right to use litigation in service of its expressive goals, and its members have a right to join together to increase.
Totally fair. And so if what the provision was doing was barring you or inhibiting you from going to court, right, which is the line of cases, Button and Primus and all those. So if it's inhibiting you getting a lawyer or filing suit or doing all those things, that seems totally correct, right? The problem is this provision is doing the opposite, right? It's forcing you into court, right? It's the opposite. Instead of putting a barrier to your using litigation or availing yourselves of the court, it instead is saying effectively, you can use the court. You are free to use the court. In fact, because we have some concern about the misuse or abuse of these types of suits, you can only use the court because we want to ensure that the relief that you're getting from these suits is limited to relief that you're lawfully entitled to. And so we want judges deciding rather than, using what they claim, and I'm not accepting it, but they claim as sort of strong-arm tactics to force, CBA agreements, right? And so I'm having trouble understanding how that's inhibiting you getting into court. It's forcing you into court, right?
It's forcing you to litigate your case to absolute conclusion, to final judgment.
Right, and so what case do I look at? Because none of the cases you cite are that direction. They're inhibitions to you getting to court, right? This is a forcing you to court. Why would we think that's a First Amendment problem? I have all kinds of problems, but why is that a First Amendment problem? It's not an access to the court case at all.
Well, Your Honor, I think that you're right that this is a very unique law. And so we don't necessarily have parallels in the case law. However, the case law discussing the importance of settlement, which is cited in our brief, I think we all recognize that settlement is critical to the ability to litigate. Now, it doesn't mean you can...
That's a great policy argument, right? Maybe that's a good thing. Like, talk to your legislature, right? But like, what I don't see is that like settlement is being a First Amendment value, right? It is really important. Like I like settlements too, right? Judges love for cases to go away. But like the First Amendment doesn't make me like it. It's just my like general policy preference.
I understand that, Your Honor. I think that one of the core principles of First Amendment access to the courts would have to be maybe not unlimited, but meaningful access to the courts. And I think that has to mean...
You have full access to the courts. What you don't have access to is getting away from the courts.
Well, Your Honor, I would point again to the extreme targeting here and the extreme burdens that this puts on one organization. And because of the First Amendment interest in conducting litigation, particularly when you are an expressive association, that I would say that there has to be a compelling interest to restrict settlements that are available to every other union and every other private sector worker. I think, there is a real concern because of the prohibitive costs of litigation that if cases can't be settled or there's no reasonable opportunity to settle, that cases can't be brought at all. That's just a very basic component of meaningful access to the courts and the legal system.
But I guess I go back to the sort of question. You agree that no court has ever said that or required that as a First Amendment value. We'd be sort of creating a new First Amendment right to say that.
I wouldn't say it's a new First Amendment right, but I will acknowledge that I'm not aware of precedent on this point that says that settlement is a First Amendment right. I see my time has run out. I look forward to speaking with you more on rebuttal.
Good morning, Your Honors. May it please the court. My name is Matthew Tolchin. I'm an attorney with the North Carolina Department of Justice, and I represent the Attorney General in this case. Your Honors, this case involves a facial challenge to Section 20.5 of the 2017 Farm Act, which was passed to strengthen North Carolina's right to work policy. As this court knows, facial challenges are disfavored, and there is a strong presumption that the law is constitutional. And as my colleague, counsel plaintiffs pointed out, there's two provisions of this case, the checkoff provision and the settlement provision. And the plaintiff must show that under no set of circumstances would either provision be valid. And plaintiffs can't do so in this case. And one of the reasons for that is this is an economic regulation of contracts. And it was enacted to protect the farmers and the agricultural industry. And the agriculture industry is the largest and most important industry in North Carolina.
So, Counselor, one of the things that your colleague on the other side did not talk about, and we haven't talked about yet, is what these provisions say. And to me, that might be a good starting point. If you
Yes,
could
Your Honor.
briefly
I'll start with the settlement provision first, Your Honor. And our contention is that the district court erred in striking down that provision for three main reasons. The first, as Your Honor pointed out, the plain language of the statute makes clear that it applies to only certain settlement conditions, not even settlement agreements, but provisions of settlement agreements. The second reason is defendant's interpretation of the statute is reasonable and would save it from unconstitutionality.
Well, let me ask you that, because Judge Richardson asked you, do you agree it would be unconstitutional if it was interpreted the way the plaintiffs say it should be?
Your Honor, I think there are several situations where, yes, it would be. And the reason for that is, if you look at...
It would be okay or it would not be okay?
It would be, constitutional, Your Honor. And the reason for that is because the right at issue, collective bargaining, is not a constitutional right. And that's established by the U.S. Supreme Court and many other courts. And that's the fundamental right at issue.
Do you also agree that the First Amendment doesn't include a right to settle?
Yes, Your Honor. And I think in terms of, if you look at a settlement, what is a settlement? It's a contract. And so this is a type of regulation of contracts. And there are many examples of where legislators have restricted certain types of settlements, medical malpractice being one. But, Your Honor, to your point, the issue, the behavior at issue or the coercive actions at issue that the legislative tried to address don't involve lawsuits involving unions. They're not brought by Flock or other unions. These are lawsuits brought by individual plaintiffs, not challenging CBAs. It's usually involving violations of Fair Labor Standards Act. And yet, these individual plaintiffs who are represented by Flock's general counsel, as terms of settling their lawsuit, are trying to coerce farmers into a settlement that recognizes Flock a non-party.
So I understand the policy, but can you address Judge Mott, what I think Judge Mott's question was, and help me understand? I mean, this is not a model of clarity statute, I think.
Well,
we might agree on. And can you help me understand why we should interpret this, assuming we have to interpret it at all, but why we would interpret the conditions upon language to require two agreements, right? I mean, I take the argument to be that if you're conditioning a provision that is conditioned upon something else, the something else must be external, but I'm not frankly sure I totally follow the argument. So
Well, Your
can you
Honor,
help me?
The best place to start is, let's start with the statute,
Right.
okay? And so the district court and the plaintiffs asked this court to interpret the statute as broadly prohibiting all settlement agreements between agriculture producers and unions. But if you
The state's
take...
position is that it does not do that. And what is the state's position
So-
about what it does do?
So the reason that reading is in our position overbroad and incorrect is it ignores the very first line of the statute, which you read, it says, any provision that directly or indirectly conditions. And so if you take this the settlement provision as meaning it applies to all agreements, then it renders that condition of being either a union employer or non-union employer absolutely superfluous. And not only that, that interpretation also ignores the the amended language, the language that was amended to the statute, which focuses on the provisions of the agreements. And if you look at the language that was amended and added, it specifically says the terms of an agreement. So by reading it broadly, you are rendering the amended language and also the purpose of the statute as being meaningless. And again, this is a facial challenge. And so you need to presume that the legislation is constitutional. And if you look at the context and the legislative history behind the amendment of the statute, it supports a narrower reading. Because again,
This would be helpful. So I think I know your answer to this, but I want to make sure. So give me an example of what you think a quintessential type of thing this statute forbids.
so
Like what's, the scenario is, but for this statute, the following would be legal. Because of this statute, that thing is now illegal. What is that thing?
So the thing is that's illegal is exactly what the statute is intended to prevent. It's the coercive lawsuits that are brought against by, individual plaintiffs. Sorry, it's the use of litigation as coercing farmers into
No,
entry
that's a
of
description of
collective
of your normative force of what's. I want literally. There's a lawsuit between X and Y. There's an agreement that says Z, and that's now illegal. Just describe that to me.
The Z that's illegal is, in order to settle this lawsuit, you must recognize flock.
So an individual agricultural worker sues their employer, and then and that's X and Y, the employee and their employer, and X and Y settle, and as a condition of X and Y's settlement, Y has to recognize Z as a union. That's
Not only recognize it, enter into a collective bargaining agreement.
enter into collective bargaining
Yes,
agreement with Z.
Your Honor.
That's okay. That's what you think is the
And
quintessential.
so what the law is intended to do is to separate out that function, as Judge Richardson pointed out, separate out this collective bargaining aspect of it from the lawsuits and the use of coercion or use of a threat of litigation or impending litigation to force a farmer to enter into a collective bargaining act. And so the General Assembly was aware of these lawsuits and was aware of the problem with these lawsuits. And so it amended the statute to focus just on that aspect. And again, so the focus on that aspect, if you take plaintiffs and the district court's interpretation by broadly outlawing all settlement agreements, it doesn't focus on that. It doesn't at all, because flock is a non-party. The union is a non-party to that. And also, if you look at the overall structure of the right to work statute in general, if you look at the original right to work statute, which focused on the terms of agreements between unions and employers. And the amendment of the first, when this was amended back in 2013, it focused on provisions of a purchase agreements. And the issue there was the use of threat of unions into trying to get favorable terms or different terms into purchase agreements. And so that's why it was amended in 2013 to focus on the provisions of the purchase agreements. And it's the same is true in this case. It focuses on the terms of a settlement. It doesn't prevent the union or individual plaintiffs from filing lawsuits. It doesn't prevent the union or plaintiffs from settling lawsuits. It doesn't prevent any of that.
So your position would be that there is no possible, you don't even need to go to the First Amendment or any of the constitutional claims, because this is that correct?
Correct, Your Honor.
All right, but if you're looking at the dues provision, you make the same kind of argument, and I'm not sure it works with respect to the dues provision, does it?
Well, Your Honor, I think it does if you look at the behavior that the dues checkoff provision and the rights at issue there. The fundamental right at issue, and this is what the plaintiffs are arguing, is they have a right to dues checkoffs. And that argument is directly contrary to this court's ruling in Campbell and also U.S. Supreme Court precedent. Their unions do not have a constitutional right to payroll deductions, regardless if they use that money for expressive activity. And as this court explained in Campbell, the reason for that, First Amendment isn't implicated because prohibiting dues checkoffs, and this is where I quote, does not prohibit, regulate, or restrict the right of unions to associate, to solicit members to express its views, to publish or disseminate material, to engage in political activities, or to affiliate or cooperate with other groups. And that site, just for the court, is 883 Federal 2nd at 1256. And the reason for that is it's far too attenuated to expressive activity. Preventing dues checkoffs doesn't have any impact on first expressive activities. The laws doesn't prevent or prohibit dues checkoffs at all. It just prevents agreements that require farmers to act as treasurers for a union, and if they fail to do so, to face severe financial privilege. That's all it does.
So because of that, it doesn't violate any of these constitutional provisions either.
It doesn't affect the First
According
Amendment.
to the
provision.
state.
Correct, Your Honor. But even if the First Amendment is implicated in this case, and in our position, obviously it doesn't, the provision is still constitutional because it's viewpoint and content neutral, and it's narrowly tailored to support a substantial government interest. I mean, like the statute at issue in Campbell, it's facially neutral. It doesn't target out any subset of message or for disfavor. It applies to any agricultural union or producer.
What do you say to your colleague's argument that it just so happens that it only targets one, I agree that on its face it's neutral, but what do you say to your colleague's argument that it just so happens to hit only one union?
Well, Your Honor, the fact that it is allegedly the only union doesn't prevent the legislator from enacting legislation that impacts the agriculture union. I mean, if you take that to its full conclusion, it would render strict scrutiny to any regulation that affects the agriculture industry. But you don't even, if you take it
Doesn't
farther.
it also affect, I mean, when we look at both of these provisions, I mean, the settlement provision is more obvious. I mean, the people that might be most upset by the settlement provision may well be some of the farmers, right? Because they too are forced into court and have to litigate instead of resolving cases. I mean, they've been voluntarily entering these agreements, which means to me that they would prefer to have settled them, at least the ones that did, in the manner they did rather than go to suit. And now they have to go to suit. So it seems to me that it is imposed, the settlement provision most plainly is imposing a burden both on the union and all the farmers who are potentially in litigation with them, right? I mean, that one's not targeting the union alone, it's targeting both sides of those voluntary agreements.
Correct, Your Honor. And in this case, but the law, as the district court interpreted it, and as it is written, doesn't prevent dues checkoffs at all. It just prevents contracts that require farmers to do it. It's still voluntary.
I think the question switched to the settlement agreement, not to the dues
I think it's the
checkoff.
same, I think the same thing plays with the
But I think it's
settlement agreement.
clear.
Right. So Judge Richardson, to your point, and this is the reason why in the checkoff provision, I think it's a little bit more important, is that there is no bar on farmers entering into dues checkoff.
All right, so can I ask you this question, which is maybe a little esoteric, but we seem to have two choices here with the checkoff provision. One, we could narrowly interpret the checkoff provision as you've suggested, right, contrary to your colleagues. And if we did that, then the First Amendment question is easier. We might say easy, but I'll just say easier. But in doing so, we're like intruding on the state to interpret their statute for which there's a dispute about how to interpret it. The other option, right, is to say, even under the broader interpretation, there's still no First Amendment problem. And that seemed, is harder than the first question, but avoids, this court entangling ourselves in, North Carolina statutory interpretation. Do you have a sense of, one sort of like a little bit of constitutional avoidance, one's a little bit of like avoid interpreting state statutes as a federal court, both seem like sort of values. Do you have a thought about which one we ought to be doing?
Well, Your Honor, I think there's two answers to that. One, I think based on precedent, not only from this court, the U.S. Supreme Court, is from a dues checkoff provision, there is no First Amendment issue. But even if there is, I think in terms of
Well, but we would have to resolve the public-private issue.
Well, the public-private issue doesn't change the right.
I understand that, but what I'm saying is that would be an additional issue we'd have to resolve that we really probably would not have to resolve if it was just permissive.
And so this goes to our, the issue that we raised in our briefs, and we talked about, and particularly with regard to the settlement provision where the district court erred, and that's in terms of the principles of constitutional interpretation and constitutional avoidance. And when you're interpreting a statute, which is what courts do on a regular basis, even federal courts have to interpret state law. That's what this case is centered on, is focusing on a state law. So, and in order to do so, the district court should look to the state law's constitutional rules of canyons of interpretation. And North Carolina courts have long applied a presumption against construing a statute in a way that would make it unconstitutional. And the district court failed to do that in the settlement provision context here, and obviously did so in the checkoff provision, which is proper. And so the defendant's interpretation of the statute is constitutional. So, Your Honor, I see my time is up, and I'd like to reserve the remaining time for...
You would agree that there are a number of ways to write this opinion, right? Okay?
Yes, yes, Your Honor. It's like that.
Okay. We have some rebuttal?
Yes, thank you. To address some of my colleagues' arguments about the dues checkoff provision, we've said this in our briefing, but it bears repeating. This is not about whether there is a constitutional right to dues checkoffs. This is about targeting a single union for extreme burdens to fundraising that other unions do not experience, comparably situated unions are not experiencing. And the question is really whether a state can target a single expressive association, here FLOC, and this court has said that unions like the NAACP, like the ACLU, are archetypal expressive associations. Whether
Help me understand the question here. So you say it targets the union, but the checkoff provision like bars agreements, which means it targets two different people, right? It targets both well, maybe in this case three, right? Like a union as the beneficiary, but really the two people it's actually targeting, I think, is the employee and the employer, right? And so the effect is maybe felt most by the union because they're getting the money. But the truth is the farmer too, right, may want to do this to encourage his workers and to have good morale and all the sorts of things he might really want the union, right? Some farmers do. It sort of helps them with management and labor issues. And he's prohibited from doing that too, right? So it doesn't just bar unions from doing this. It also bars farmers from entering these types of agreements, which presumably they believe to be in their advantage before this law. And so it's not limited to unions, is it? It's unions and farmers, in which case it doesn't look so micro-targeted.
Well, I think it does, Your Honor, because again, even if you, and I agree with you, this imposes burdens on some growers as well, in the sense that there may be some agriculture producers who want to, as you say, have an agreement with the union, and this prevents them from entering. But again, I would look at, this prevents them from entering contracts that would be enterable if they were not agriculture producers. And so you still have that
Right, it means so
targeting.
it's targeting them,
Yes.
right? I mean, I get that, and the question I've got is like, then it doesn't look like Minneapolis Star and these other cases, right? Because it's actually not, it's targeting both sides of an issue, right? So it's targeting both employers and unions, right? And so in that sense, it's not like Minneapolis Star, which is focused on a single, I think it was a newspaper, I can't remember, but whatever, the single expressive organization there, it didn't have a flip side, did it?
Well, Your Honor, I think it did. One could argue, for example, that, well, let me actually get it outside of Minneapolis Star. I'm thinking about the Time Warner case, the Fifth Circuit case that's cited in our briefs. There were agreements that were being targeted for burdensome regulation, and I believe they were cable franchise agreements. You can see that would burden not only the cable company, but organizations or municipalities that might want to enter into these agreements with the cable company. So
they're all running a cable. I mean, the cable franchise agreements, they're all in that they're on the same side of that issue, right? And so that looks more micro-targeted than when you got here, you got them on both sides of the issue.
Well, maybe, and I don't want to sort of quibble too much with your taxonomy,
That's
but
it.
maybe
You're here to
there's
quibble. I'm okay with that.
Okay.
Right? Please
think,
quibble.
with respect, Your Honor, I think that saying that there are opposing sides of the issue, there may be some employers who are pro-union, as you said, and they both want to enter into these contracts, which would be a binding agreement, a commitment between employer and employee to have certain rights extend to the workers. And it's taking that away from them. It has the most adverse effect on unions, and I think we've documented that on FLOC, but that it is that micro-targeting is still happening with respect to people who want to enter into these kinds of agreements.
But help me just understand, why is that micro-targeting? If it has the most effect on one group, but it has an effect on another group, then we got to consider the total effect, right? I mean, then it's not like Minneapolis Star. And I get, maybe there's a Fifth Circuit case, but when I look at the Supreme Court cases, they don't seem to look like that.
Well, I think Arkansas Writers Project is another example of a situation where maybe both sides are being impacted by the taxation, because it's a sales tax, so on a subset of magazines. And so you can see there that the purchaser would be impacted adversely, but also the creator of those magazines, the publisher of the magazines. And I would just point out, with regard to interpreting this provision, the dues checkoff provision, as discretionary, and that this is going to save the statute, even if the dues checkoff provision were interpreted to allow discretionary agreements, it's still incredibly burdensome. We all know contracts are important in American life, and the ability to not secure these contracts is very problematic. Those binding, consistent agreements that our economy runs on. Further, if there's no right to these binding contracts under the, or no option for these binding contracts, I should say, there is the specter of being prosecuted for conspiring to entering into binding contracts. And there's a real threat here of criminal and civil liability, where unions may be trying to enter into discretionary agreements that are allowed by the law, but may run afoul of overzealous accusations that they're trying to enter into binding contracts. So there's a real chilling effect here. Turning to the arguments that were made about the settlement provision, obviously we believe that the district court's interpretation was correct. And as Judge Richardson noted, federal courts are not free to impose narrowing interpretations on state statutes unless those interpretations are readily apparent. And this is not a model of clarity. It is not readily apparent that rewriting the statute in the way that defendant wishes would work to save it here.
So if you had to make the order of this, that isn't a fair question for you. Never mind.
And also problematically, this narrowed interpretation is not binding on state courts. You know there are 100 counties in North Carolina, so we have a real problem of the threat here. But even if that narrowed interpretation were correct, the settlement provision is still unconstitutional for the reasons we outlined in our brief, that FLOC members have a well-established First Amendment right to join together to pursue litigation in support of shared goals, whether as a form of public advocacy or simply a practical means of gaining meaningful access to the legal system.
So you make a bunch of constitutional arguments.
Yes.
And you regard the First Amendment as your strongest constitutional basis?
I would say so, Your Honor. We do think our equal protection argument is strong as well, and we haven't had an opportunity.
Now, we all love all our children, but I asked you if you spent all the time on the First Amendment.
I think we see this primarily as a First Amendment targeting case, if you will, Your Honor. And to conclude, I see my time has expired. We would respectfully ask the court to reverse the district court's decision upholding the dues checkoff provision, to affirm the district court's injunction against the settlement provision, and to direct entry of judgment for plaintiffs on their First Amendment and equal protection claims. Thank you.
Thank you, Your Honor. I'll try to, since I didn't do so well the first time in clearing up these issues, I'll try again.
I'm sorry, I did have one question for you on the equal protection argument that I want to make sure I don't forget. So when I look at, this is page 3011 of the joint appendix, I see the district court saying that after reviewing the record, it, quote, remained equally plausible or perhaps even more plausible that anti-union views rather than bias against Latinx non-citizens motivated this enactment. If this were a bench trial, that seems totally unproblematic to me. How is that consistent with Rule 56 to then grant summary judgment after saying it is equally plausible, it means X or it means Y?
Well, I think we wouldn't agree that the district.
No, I know, but you'd agree that under Rule 56, if a district court thinks two things are equally plausible, you should not be granting summary judgment.
Because I think that that's not the deciding issue in terms of from deciding the legal issue, Your Honor. And I think it goes to, there's a couple different analyses that the district court then goes to and then determines the scope and the reasons behind the statute, the enacting of the statute. So, for example, Your Honor, there are many reasons, non-discriminatory reasons, valid non-discriminatory reasons why the General Assembly enacted the statute. Your Honor, again, as a facial challenge, that the presumption of the law is constitutional. And as this court admonished in Raymond, and also as precedent stamps, the motives of individual legislators can't be imputed to the whole General Assembly on its own, Your Honor.
Thank you. I distracted you from where you wanted to go, but I wanted to ask that before you got into it.
No, thank you, Your Honor. But I think the big picture here is really standard of review. And the First Amendment has many different standards of review. And so our position is that there is no First Amendment right. But even if the First Amendment right was implicated, it doesn't require the strict or heightened scrutiny that plaintiffs are advocating. And a couple reasons for that is, one is the statutes don't prohibit all conduct in general, overall conduct. Farmers are still allowed to use checkoffs if within their discretion of their employees, and a lot of employers will do so and do so. And farmers are entitled to enter into collective bargaining agreements. That's not prohibited. And I would point out, Your Honors, that the General Assembly could, without violating the First Amendment or any law, prohibit all dues checkoffs, unions from doing it completely. And it tried to do so in previous versions of the statute, but it didn't have the votes. And so if you look about the targeting treatment claim, the statute is facially neutral, Your Honor, and that's in terms of Campbell. Campbell made the same arguments. The union in Campbell made the string arguments. They said that we were targeted as retaliation for our political beliefs. And so this court cautioned that you can't look behind the motives of the legislator in a facially neutral statute, which this is. And I also would say that in cases subsequent to Minnesota Star, they have said that there's different treatment of classes, within classes, can be justified by special characteristics. And so the record clearly shows why the agricultural industry in specifically is different, and it's treated differently. For a reason, the state has a long-standing history of protecting the agricultural industry.
Can I ask one quick question
Sure.
before your time runs out? If you assume just for a minute that we adopted the broad reading of the settlement provision, so in other words, it bars all settlements, or we chose not to answer that question because it didn't matter for the First Amendment question, what would the rational basis be for barring all settlements? I get the rational basis for barring the type of quote-unquote coercive settlements that we've talked about, but what would the rational basis be for barring all settlements?
I think there's a couple of reasons. One, I think if you look at the collective bargaining aspect of it in terms of the right to work policy, it's just a strong way of doing that. Or it's also a way of forcing unions and farmers to collectively bargaining rather than using the courts to achieve that goal. And that's a legitimate way of a legislator of deciding what the courts should be used for. And so that's one of the reasons that it would do so. And if you
I'm sorry, I didn't understand that. It's better to force people into court than to have them agree?
Sorry. It's rather than force parties into court to enter into collective bargaining, you separate the litigation aspect of it out so that you do collective bargaining, just as any employer and union will do, rather than using a lawsuit as a basis of that. And so that's what the language targets. It's as a condition to settle a lawsuit, right? And so if you broadly prohibit settlement agreements between unions and employers, you are taking the litigation aspect out of it. It doesn't outlaw collective bargaining, which it could, without violating the Constitution. And so that would be a broad reading of it, Your Honor. And I would just write that we're not advocating a rewrite of the statute. Our position is that the district court wrongly interpreted the settlement provision and that as written under its plain terms, It does what the defendant says it does, but the court didn't even need to determine whether the defendant's interpretation of the statute was correct. It only needed to determine whether it was plausible, because this is a facial challenge. And defendant's interpretation is plainly plausible because it would save it from its unconstitutionality. I see that my time is up, Your Honor. We would just ask that the court reverse the district court's decision granting summary judgment to the plaintiffs and affirm its decision to grant summary judgment to the defendant. Thank you, Your Honors.
Thank you both for your arguments. As you know, we usually come down and greet you, but conditions prevent it now. But we appreciate your arguments, and we look forward to seeing you the next time. I think we'll go directly to our next case.
Thank you, Your Honors. May it please the court, my name is Patrick Perotti with Morgan & Bernstein in Cleveland, Ohio, on behalf of the appellant. We would like to start out with the question that the court asked. The court asked us, is the CAFA jurisdictional exemption equivalent to the 11th Amendment immunity that we discussed in the briefing on both sides? And I haven't had a chance to talk to my opposing counsel, but our position is it is. Both of those hinge on whether there's a bar to a judgment. Here, the bar would be immunity. Now, the district court found that there's no immunity. Therefore, the defendant can be subject to a judgment. And why, assuming that we want to get into that issue, we think the court is right, but just to talk about it briefly, why is the court right? Is because the question is who pays? As the court said in Hess, and as this court said in, I think it was Rustock, that's the determining focus of this six-part test.
Could I stop you there, because you've already pivoted to the 11th Amendment, and I'm not sure that's right. So I'm looking at the statute, D5A. It doesn't say would be foreclosed. I mean, if the statute said is foreclosed or would be foreclosed, I totally get you. But the statute doesn't say is foreclosed or would be foreclosed. It says may be foreclosed. Which presumably maybe means something different. What do I do with the words maybe? Doesn't that suggest it's not whether it is foreclosed, it's whether it may be foreclosed by?
To tell you the truth, I don't know what you do with that. Because if we're to read maybe as any possibility, then that means that under no circumstances could there ever be a case in a federal court by a foreign citizen against another state.
Maybe that's the right answer. Why is that not the right answer? Well, hold on. Not never. You can't use CAFA, right? So CAFA itself.
You can't use CAFA.
So that can't be right. So first of all, if you have federal question jurisdiction under 1331, this statute is irrelevant.
Correct.
If you have what I guess I'll call regular diversity jurisdiction, this statute is irrelevant. This statute only comes into play when you're trying to bring a state law claim in which there is not complete diversity. So it's a subset. I mean, I agree it's not insignificant, but it's not that no foreign citizen could ever sue a foreign state.
A state law claim where there is either not complete diversity or where there is complete diversity but the minimum controversy, there's no $5,000.
Sure, but I mean, I guess when I put it that way, it doesn't strike me as totally implausible that Congress would have meant to do that.
Well,
That would
doesn't
be
it-
a sea
couldn't-
change to what happens in federal courts, and I can.
Couldn't may be an indication that somebody could waive it?
Yeah, absolutely, and that was the rest of my answer is
Well,
that the
okay.
issue.
Maybe start with that.
The issue of immunity can be waived. All right, the state can
Yeah.
consent to jurisdiction of the federal court in order to grant a judgment in money, and it can be waived. It must then. I don't have the case in front of me, and if you want subsequent briefing, we can do that. But the U.S. Supreme Court has said that the federal courts don't invite issues. They wait to see if they are raised. This is a defense. It has to be raised.
Well, wait, hold up. But you want to cite that case? I can cite a whole bunch of cases that say federal courts have an obligation to assure themselves they have jurisdiction. This isn't a jurisdictional statute.
I don't know if this is a jurisdictional question rather than a deferral of exercising. I think there's jurisdiction here. The court has jurisdiction based on CAFA. The question is,
But I'm not sure that we do, because the first words of D5 are paragraphs 2 through 4 shall not apply if. Well, 2 is the thing that you're relying on to give you jurisdiction in the first place. So if we're covered by this statute, then we don't actually have jurisdiction.
I may be wrong, and this may be something that the court would look at in the first instance, but I think rather the court determines its jurisdiction than determines, is there a defense been raised by a party who has the right to raise it, the state, a state official, or a state agency, that would bar a judgment. And otherwise, I can cite you, not now, but in anything post-argument, I can cite you dozens of cases under CAFA in which private citizens of states have sued other states in class actions for relief in federal courts.
So I was not able to locate any opinion that really addresses this specific
There
question.
isn't.
You were not able? Okay.
We couldn't find one either. No, but we believe it was correct because we believe it hinges on whether there is immunity. There clearly is an immunity, and I'm not going to spend much time on that.
Can I go back? I mean, you wanted to say, the parade of horribles that you suggested was interpreting may be foreclosed to mean even possible.
Yes.
Right? Sort of, but you know, we often think about may is sort of a plausibility standard, like if there's a plausible claim, right? And so we got to do the first part, right? Is the defendant a state official or a government entity? And it seems that we have a government entity here. So it's narrowed down that at least the Parkway is a government entity. But why don't we read may be foreclosed to mean there has to just be a plausible claim that relief is foreclosed?
Well, then that would eliminate the jurisdiction in the federal courts for CAFA cases, even when you look through the law and facts and you find out that there is no immunity. There is
yes,
no bar.
that's exactly right.
And I don't believe that that's what this means or this should be interpreted to.
But okay, do you have another argument other than that would be really bad policy?
I have the argument that when Congress grants jurisdiction, it doesn't grant it in a way that allows arbitrary actions by a federal court which would ignore the facts or the law. And here, when you get down to the bottom line, there is no immunity. There's no question about that. There's neither legal immunity nor under Hess, nor is there functional equivalency immunity. Because all the arguments that have been made here were rejected correctly by the district judge because the state of West Virginia is not liable and is not functionally equivalent to being liable for any of the judgment that I might collect against this agency at all. Hess makes it, as Justice Ginsburg of blessed memory said in her opinion in Hess, they made that exact same argument. They said, but wait, the agency sometimes contributes money to the state, and since it does, if you were to take a judgment against the agency that would lessen the amount of money it could contribute to the state, Justice Ginsburg said, no. You don't look at the profits and benefits of the agency, you look at the liabilities and the detriments. And so that issue really, as far as.
Why does that make sense? I mean, assuming that the court said that, why would it make sense to look at liabilities but not profits? I mean, just from a perspective of why would that ruling make sense? I'm not sure that you have to read Hess that way, but why would it make sense to look at liabilities but not profits?
Because as the court said, and as the Supreme Court said, the determinative standard is who pays. And in this case,
Right, but the paying of an opportunity cost and the paying of an actual check, like, is not economically different.
That's not, I respectfully disagree. In Hess, the court specifically addressed this idea that since an agency is part of a state, no question, and the agency may contribute money, no question, that therefore the agency is the state and there's immunity. That's not what the standard under the 11th Amendment is. The standard is under 17-16A2 of the West Virginia Code. Not only are they not liable for this, contrary to what they say on page 27 of their brief, in which they cite Appendix 25 through 29, that's not what Appendix 25 through 29 says. That's an insurance policy. They cite that section as saying that the state has indirect liability, that the state's credit rating is affected, and that all sorts of horribles will happen to the state when under this statute, none of that happens to the state. And that's exactly what was addressed in Hess. And Hess is controlling authority. Hess is right on point to this issue. If I may now, with your permission, move quickly to the other issue, the issue of the APA exemption. The defendant managed to misfocus the district court on what was the source of the challenge rule, of the challenge sanction fee here. Was it the Electronic Toll Collection Act, or was it the Enabling Act? But that makes no difference. She was charged as sanction. So that's an agency action. The only question is, was that agency action, that rule, exempt from the Administrative Procedure Act? And we don't dispute that these fees are legislative rules under the West Virginia APA. Neither does the defendant. Those require rulemaking. And why are they legislative rules? Because they subject the individual to a criminal liability. It says so right on the ticket.
So can I tell you, I think the hardest question for me about your position on this issue is the one the district court identified. What is it that you think that in the real world the provided clause actually accomplishes? Because the provided clause seems to me to say, well, so as I read the statute, tell me if I got this wrong. In general, if you want to impose tolls on roads in West Virginia, you need approval from the state legislature, provided that that requirement does not apply to the turnpike. But as I read your argument, it says, well, it turns out that under the turnpike, you also have to do that because those are legislative rules that under the APA means you have to go through the legislature. So then it turns out that that provided clause doesn't really do anything in the world, and that strikes me as an implausible interpretation of West Virginia law.
And
so what's the best response to that?
You're right and you're wrong.
Great.
As Judge Mott said, let's look at the statute in the last argument. Let's look at the words. That's not what the words of the statute say. The words of the statute specifically say, and I have a copy if you need, it's 1716A13. It says the Parkway Authority is authorized to fix, revise, charge, and collect tolls and fees. So they have the authority to assess these charges. They could assess it for the toll of the transit of the road. They could assess it for a penalty. They could assess it for whatever they want. There's two things in West Virginia that require rulemaking. The APA does. This statute also does independently. It goes on to say, provided that the Parkway Authority may not charge tolls or fees for transit over an existing road without express legislative authorization for charging the toll or fee. What we're challenging here is not a toll or fee for transit over a road. We are challenging a penalty and a notification fee, which is in a totally different section of the West Virginia Code. The exemption that the district court found, which was correct for this part of the code, is provided that an existing road does not include the West Virginia Turnpike. We agree with that. The West Virginia Turnpike does not have to comply with this section of the West Virginia Code that indicates you must do rulemaking when you're enacting tolls or fees for transit over the road. That's not the rules we're talking about here. The rules we're talking about here are rules that come in to impose a penalty, and if you look at, and this is JA 140, District Court's opinion, first full paragraph, second sentence. The judge summarizes the issue and the problem exactly. When an agency implements a legislative rule, it must do so in compliance with the APA unless explicitly exempted from doing so. Agreed. The Parkway Authority, however, is correct that it is exempt from the legislative rulemaking process when implementing and collecting tolls and fees related to travel over the turnpike. That's incorrect. That's not what the law says. It is exempt from this section when you are dealing with the enactment of tolls and fees for transit over the turnpike. We are looking at section F, West Virginia Code 17-16D5. And I'll give you a couple of seconds if you have that up there. If you would like a copy, I have some. Your Honor, does the court have it, or? It's 17-16D-5.
Okay.
And it's F. In addition to the amount of unpaid tolls, this is the legislature speaking. We're telling you folks, this is something different. In addition to the existing tolls, that's what they're saying to. The authority shall assess a reasonable administrative fee in the amount determined by rule promulgated by the authority. There's no exemption there from the APA or from anything. This is separate. Look at 17-16D-14, which is the last section of this part of the code. Rule-making authority, 17-16D-14. The Commissioner of Motor Vehicles and Parkway Authority, the defendant, shall propose rules for legislative approval in accordance with the APA for the implementation of this article. There is no exemption anywhere in the code. The exemption that they're talking about and that the district court talked about was an exemption for a separate section of Virginia law that said, regardless of whether it imposes a sanction, regardless of whether it meets the definition of a legislative rule, folks in the Turnpike Authority, if you're gonna assess tolls for the transit over an existing road, you're gonna go to legislative rulemaking except for the Turnpike. We don't have a problem with that. They can pass all the tolls they want without legislative rulemaking. This is not a toll for transit over an existing road. And I'll reserve the rest of my time for response unless you have a question. Thank you.
Could you possibly address that argument first, so I can keep your...
Yeah, absolutely.
Thank you.
Your Honor, and good morning. My name is Stuart McMillan on behalf of the Parkways Authority. I think that we're jumping to code provisions that should not be jumped to.
Well, I don't think this argument was made in the briefs, but maybe your colleague will correct me.
Well, the argument that we have made is the authority derives from 1716A, the enabling statute, Your Honor. What counsel was referring to is the electronic toll statute, D, 16D. This has nothing to do with the electronic tolls. This is in the record of a cash toll booth. The verification form that was issued and sent to Miss Monaco was collected manually and sent to her.
How could we possibly consider that under 12b-6?
Well, Your Honor, is because when they made the actual complaint itself, it's talking about a cash toll.
Right, so you're essentially saying, objection, that's not true. I
No,
don't think
Your
you can
Honor,
do
I'm
that.
saying that it is true.
Okay,
Absolutely true.
okay, it is true.
So in that context, Your Honor, counsel is jumping to the wrong statutory provision. We at the Parkways Authority have had the authority to issue the tolls and the fees associated with those for over 70 years. That has not changed. Furthermore, Your Honor, if you look through section...
Just so I understand, I want to make sure I understand the argument you're making. What you're saying is that Monaco's complaint in paragraph 30 alleges that she encountered cash-only toll booths.
Yes.
And therefore, all these provisions talking about electronic tolls, she pled don't apply to her.
They don't apply by pleading that she went through a cash vault. We don't, well, frankly, it's not even set up the way it's supposed to be. In the future, we will have more of electronic. We're not there yet, but yes, Your Honor, that is right. And that's
I don't care about the real world, right? Like, I'm unfortunately an appellate judge, right? Real world doesn't really matter.
I hear you.
Right, but your position is, because I didn't exactly follow the provisions, the point of the D provisions is that they're for electronic tolls.
Yes.
Since she pled in paragraph 30 that she, quote, encountered cash-only toll booths on the West Virginia Turnpike, we now know that, based on her own pleading at 12b-6, that the D provisions don't apply.
That's correct, Your Honor. And furthermore, in the record, or her actual handwritten where she signed the verification about not paying the toll, and that's how they got the information. So it was clear and undisputed that this is dealing with the cash toll.
Right, but I can't consider what's in the record at the 12b-6. Right? I mean, I'm just relying on the complaint.
I understand. But it's just to make you feel good about it. It's in the record.
That never bothers me.
Okay, well, all right, fair
It
enough.
always feels good.
There we go. Thank you, Judge Mott. So with respect to the issues that was addressed at the beginning regarding CAFA, there is some jurisdiction out there. The 11th and 9th Circuit have looked at it, not quite on point.
Those decisions, the decisions that I'm aware of are about who is the primary defendant question, not about this question, right?
Right, but there's some dicta in there, Judge. And
Out of circuit dicta about an issue that was not the one before us?
Well, hold on a second.
Tell me more.
At least
I
it was a
will.
published opinion.
Hold on, I'm setting it up so you can be, here we go. In the 9th Circuit, there was a discussion about the use of the may, and what does that mean? Judge Richardson hit it on the head. The idea of how it works is simply this. If it's plausible, and there may be immunity, you are foreclosed. You have no jurisdiction. It is absolutely a jurisdictional issue. Absolutely. And we contested jurisdiction, not right quite on CAFA, albeit, but we did question jurisdiction under 11th Amendment. How this works under CAFA and looking at it and reading some of the dicta and how it makes sense in the statutory construction is if you're looking at a case and you have a state actor. Here we have the Parkways Authority, which in my view is the state of West Virginia. But if you have
But you don't actually have to make that claim, right? Because you can make the narrower claim that it is a government entity, and that seems really hard to debate.
Judge Richardson, you're right. You don't have to go all the way to the immunity finding, although we do have immunity under 11th Amendment. But Judge Richardson, you don't have to go there. The may is, hey, could this be foreclosed? Here we have a state actor. Let's think about the Parkways.
Do you think, so let me go back, because you used, I think he used maybe might, you used could. Help me understand what you believe may means here. How do we interpret that? Is that like a plausibility standard? I mean, if a purely private citizen showed up and said, oh yeah, but I'm a government, I'm gonna claim that I've got 11th Amendment immunity, right? Which would be implausible, but he's alleged it. That wouldn't be sufficient, I assume. And so help me understand how I draw the line. How plausible or how likely does it have to be that your immunity claim works?
We don't have a standard yet, and I take it that's something that we're going to develop. But I can tell you, looking at the dicta from the 9th Circuit, in that instance, there was a private company that did governmental functions. And they asserted that we have immunity because what we're doing is for the government. But that, we know from jurisprudence throughout the country, has been found, no, you really are not going to get immunity. So it has to be more than just coming up there and saying with some sort of naked assertion that I'm the state of West Virginia and I'm entitled to immunity. I think you have to go a little further. You have to, in the record, you have to establish that we're a state entity for jurisdiction. Jurisdiction, you have a record. You have to have some record of why you don't have jurisdiction or why you do have jurisdiction. So you have to say that we're a state agency. That's not hard to do. You have a governmental framework and a statutory scheme that is replete to saying we're a state agency.
And that's the first, just so I'm understanding, right, that's the first part of it, where the statute says, shall not apply to any class action in which the primary defendant are state official, or government entity. So you actually have to prove that piece, that you are a government entity. And then step two is, well, may relief be foreclosed? And that's the probabilistic story.
But can I ask you about the second thing, that you're proving that you are a state agency? Is the
I had my
11th Amendment analysis identical here?
It's a little different, Your Honor, and this
It
is
is,
why I
huh?
say this.
With respect to this issue?
No, it's not. It's not identical, and this is why.
Okay.
And it's because you can find that there is a state actor, and there may be immunity, but you don't necessarily have to make the finding under the 11th Amendment that there is or is not immunity. I think that's what the may has to mean. Your
No, but if this is a group that is clearly not entitled to 11th Amendment immunity, if this is a separate and independent, because they deal with all their money, for the various factors that you look at.
Right.
Isn't that controlling?
Yes. I mean, if you look at something and you can tell on its face that it's not going to get 11th Amendment immunity, then that exemption would not apply. I would agree with
But
that.
at the first, it still would have, the first step of it would still apply, right? Because it would still be a government entity, right?
Right.
So like, take it's a county, right? We all know that 11th Amendment doesn't apply to a county, but if we're applying the test, right, is the primary defendant a government entity? Yes.
Right.
Right? May relief be foreclosed? No. Right? So it loses, but not because it's not a government entity, it's because their claim for 11th Amendment immunity is not plausible.
Right. That's the analysis. But what I'm saying, what's different in the Ninth Circuit and the 11th Circuit, they even said we don't have to find 11th Amendment immunity. They say that in the case. The point of it is they're saying it may be foreclosed. So but you don't have to go all the way to that point. But if it's on its face that they're not entitled to immunity, then that exemption does not apply. That's the only way that the may has a meaning and can work here. So in this instance, we are definitely a state entity. And I would also argue that we do have 11th Amendment immunity. And I'm going to say this because if you think about how we were created, if you look at our statutory scheme, our chairman is the governor of West Virginia. Our member, the cabinet secretary of the Department of Transportation.
You're absolutely right about those factors, but you're wrong because of the funding we've always thought was the most important factor, and we're not alone there.
Well, I will say I may lose on the funding as one of them, but of course that's not dispositive, as this court said in Risto and Hutto.
So can you talk for just on the funding point, can you talk for a minute about your interpretation or reading of Hess? I mean, your colleague suggests that it's controlling. It doesn't come up till the reply brief, but the controlling Hess. Why do I read, or should I read that to suggest that it's only about paying debts and excluding consideration of a reduction in profits?
I think that I would look more to the Hutto opinion.
I know, but stay on, I mean, if we're not that familiar with Hess, that's totally fine.
Right, and because I've been more focused on.
Okay. That's totally fine. I don't want you to try to answer a question you
No,
don't know the answer
and the
to,
reason
but-
I say that, you have an entity like us, and the question is, we're not structured to retain profits. You can see in our code section, but I
So
don't.
help me understand, let me back up to that
Okay.
just for a minute. What happens if, just as a factual matter, you know this record a lot better than I do, what happens if the Parkway makes money, right? The first dollars, it looks like, goes to pay debt.
Right.
Is that right? Well,
Service the bonds that it issues.
right. So what happens when the bonds are paid off? So in the world, and I know we're not currently in this world, right? But
We're in a different world right now, yes.
totally fair. I understand how these stories work. But from a statutory perspective, right? Again, I don't worry about the real world. I live in appellate land. So what happens when the debt is paid off? Where do those dollars go?
Those monies will go to construction projects for state roads in West Virginia.
So not built by the Parkway Association, but built by DOT,
This is
or whatever
how-
y'all call your DOT.
Yeah, the Department of Transportation.
Right.
Yeah, yes, Your Honor. The reality, the
And,
practical.
and can you tell me, like, where I look to see that? Like, how do I know that the money, once debt is serviced, goes to DOT to build roads?
I think you're going to have to follow the practical effect that's been espoused by the Fourth Circuit. And I think that's important with both the Hutto and the Risto opinions.
No, but I mean, how do I see that from a statutory perspective? Like, when the Parkway Association all of a sudden says, hey, we got extra money, and they go to the statutory code and they say, what do we do with this money? Where are they looking at?
I mean, it's the way it works. It's in the state budget. I mean, we're audited by we're audited by other agencies in the state of West Virginia. That money is actually pulled out by the state in order to use in other ways. When we have surplus money in the state of West Virginia, when that happens, gosh, that's a big deal. It's pulled out, and that the reality of it is, Judge Richardson, is that there's the statutory provisions that are set out like they are. But I think it's important to understand, and this is why I'm looking at you, the practical aspect of this, of what we do.
So could we address, I'm sorry.
Okay.
I guess maybe that raises a different question, because that then sounds like a factual question, right? So if we're considering funding, as we must, or sort of the obligations as part of the 11th Amendment immunity, it seems like what you're suggesting to me is that there's like a factual story that is not in the complaint that we currently don't have about how money actually operates in the state budgetary system. And I know enough about South Carolina's budget system to know that it's like a total black box, and I assume West Virginia is not totally different.
But see, one of the things we do know is that this is within the authority's discretion.
The use of the monies that it derives from the sale of its bonds has to be dedicated to construction projects of roads in West Virginia.
Does it tell you which construction projects and when?
Well, I don't think it sets forth, but those are usually subject to the DOT, who decides where they want the construction projects to take place. So there is that.
So you have no what do you guys do? You have no discretion?
No, we have certain autonomy, Your Honor. We can enter into contracts, we can, and so forth. But the reality of it, and this is why it's so important, and this is why I focus so much on Hutto, is, and even Risto, they're really looking at the practical effect. I mean, you have to look at.
But how can we do that? I guess the question is, if we were addressing the 11th Amendment, how can we do that without like a factual development? Can we do that at?
You've done it, and you do it most of the time. And frankly, most 11th Amendment cases are found on a 12B basis. And
Well, but oftentimes that's because they're like clear statutory commands, right? And so if there's a statute that says that the state is liable for all debts, we don't need a factual development there.
We don't have that.
I know,
agree.
I understand that. But the point is that maybe you do have 11th Amendment immunity, but because we have to look at the practical consequences to determine that, at least assuming we get past CAFA, to really determine that, we actually need a factual record.
And I would take issue with you that you need a factual record on that, because I think that you've done it in Hutto and Risto without developing a factual record. I think you can figure out the
But
practical.
I don't think they had the same questions, at least that I have, about what happens to the money. Like who's getting it, who's got discretion over it, who doesn't. It seems like to me those aren't clear, and when I read the statutory commands, I had a little hard time following.
Yeah, and I think in those other cases, they don't have the governor of the state is actually the head of your organization. And so the discretion it goes to the state of West Virginia. Now, in terms of developing a factual record, my reaction to that is if you understand and looking at the code sections and how that money's used and what our role is, I mean, certainly there is a legal fiction of what we have to do, because the state can't issue bonds. It can't incur debt. So Parkways does that. We're an entity that can issue bonds. But the reality of it is all controlled by the state. The practical impact of it is the state. And to give you an example, out-of-state folks like Miss Monica who violate the tolls and don't pay the tolls and get fined for not paying the tolls after they're given notice to pay the tolls, those folks then want to disgorge the money that we have accumulated as part of our budget. And to say that would not have some effect on the state of West Virginia, and again, we're talking hypothetically, it certainly would. I'd also recommend that we look at how this deals with the dignity of a joint sovereign, the state of West Virginia. I do not know how this case on its face would not be an affront to the dignity of the state sovereignty of West Virginia. This Parkways, it is a tool of the state of West Virginia. It is an entity created by the state. It does have parts of it that are not.
This is a little bit unfair, but I mean, one feeling about looking at this entity is the state of West Virginia has, for various reasons, decided to work very hard for this not to be the state of West Virginia when it suits them to not be the state of West Virginia, and is now arguing that it is the state of West Virginia when it suits them to be the state of West Virginia. And maybe, I guess one theme of the dignity is, look, if West Virginia wants to run their turnpike through an entity, the State Department of Transportation, you can do that and you absolutely have 11th immunity. But, so just respond to that there's something about the way this whole entity is set up that we want to be the state when it suits us and we don't want to be the state when it doesn't suit us.
Well, I'd answer it this way. I hear what you're saying, but there are such situations where we do not have immunity. And I think those do have, that we've showed those some of those in our brief. There are instances where we have consented to it. For example, if there's an issue with...
That doesn't mean you didn't have immunity. It just means you've waived it.
Well, we've consented, yes, we've consented to it. I don't know if that's the same as waiver, but we've consented to it. So there are instances where we would not have immunity. But Your Honor, with all due respect, the way this legislative scheme is set up, part of it is that in order to issue bonds, the state has to create an entity to do that. And that is part of the problem, so why you see
Well, hold on, and in order for that fiction to work as a matter of West Virginia law, we have to posit that this entity isn't the state. You just told me the state can't issue debt, so you have to create us to issue debt, which means that by hypothesis, you're not the state, because otherwise it would just be the state issuing debt, which you can't do.
Well, Your Honor, that's in the context of the issuance of bonds. I don't, that's what I'm saying. There's some contexts that we would not. For example, if there is a problem with the payment of those bonds, then we are liable for that. But in this scenario, in this fact pattern, absolutely not. And the thing also, I mean, we're talking about we should comply with the APA because we're a state entity. Well, if in fact we're not a state entity, which is they're saying we are, then why are we having this conversation we have to comply with the APA? I mean, that's another way of looking at this. This is nonsensical to me, if you think about it. So I would ask this court to vacate Judge Goodwin's order, find that there is 11th Amendment immunity, but also find that the exemption under CAFA, there's no jurisdiction, if you all can do that. But I think you're going to have enough on the record to say there's a state entity and it is likely or may have immunity. That is the answer, in our view, to this case.
Thank you very much.
Thank you.
Thank you. Very quickly, we want to disgorge money from the state. Wrong. We don't. 12B, they indicated in their brief, they have the burden on a jurisdictional question.
What do you mean wrong? Like you don't want money? I'm not sure I understood your first. I didn't understand your first
We're
statement.
not seeking money from the state.
Just from the authority.
Yes, only from the authority. And if the authority has no money, we don't get a judgment.
I wasn't sure which word I was supposed to
Yes.
focus on in that
No.
sentence. I'm with you.
Develop a factual record. Absolutely right. Evidence. It's their burden on a 12B, and on a 12B, they are allowed to go divorce the record. They're allowed to bring in evidence. They could have brought in the evidence, Your Honor, that you're asking about, that showed that there was switching of money. When you said to the counsel, where does this come from in the West Virginia Code, he said, not in there. It isn't. The money doesn't go back and forth like that. That's not the way it works. Hutto, the reason why Hutto came down the way it did is because the South Carolina Constitution has a provision that indicates that the state is liable on pension plan obligations. Hoodoo is a pension plan case. When the state statutes say the state fisc is liable, then there's 11th Amendment immunity. That's not this case. Ristow, again, they went through the same thing that we had in Hess, and they asked, is there this intermingling of money and back and forth? And Ristow, South Carolina, created the Turnpike and funded it massively throughout every single year.
Where do you want me to look? And I want to just go back to Hess for a minute, and I don't want you to waste too much time on it. But do you have a pin site for where you want me to look that you believe the court rejected the idea that we look both at profits and
Page 50-51 of the U.S. Code.
50 to
or
51.
US, 531,
Yeah,
I
yeah,
think
I'm
it
good.
is, or something.
I got it. That's all I need. Thank you.
Okay. And now back to the burr under the saddle. I've got a question for the panel.
Not allowed.
Not allowed.
Go with God on that.
This weird provision of CAFA which says that if it's a state, Judge Richardson, all of you said you have to first establish that.
Or a government entity.
Government entity, the county, the city of Cleveland, wrong circuit, but
Yeah.
Cleveland, Tennessee, I don't know if Tennessee is in this circuit, but that may be foreclosed.
That's
Maybe
easy.
foreclosed by.
The answer is no. Lincoln County versus Lunning says that entity doesn't have 11th Amendment immunity.
Yeah, may be foreclosed by immunity? That's not what the statute says. It says may be foreclosed, that the district court may be foreclosed from entering a judgment. If there's a viable statute of limitations, you're foreclosed from entering a judgment. There's all sorts of defenses that foreclose the court from entering a judgment. Those defenses are all waivable. This defense is waivable. That's why it cannot mean that you simply say state actor, government entity, you're done. Because there's dozens of defenses that may foreclose that judgment. We agree that all the booths in the district court opinion, all the booths are ECTA booths. There's no such thing as a cash-only booth. We now realize that. But we also agree that the defendant has the authority under the Enabling Act to enact any kind of
Wait, can I
toll.
go back? I just realized I don't understand the point you just made about D5A. So does that mean that D5A applies in literally every case, or that it never? I don't really understand. You're right. Every defendant may have some defense that would foreclose relief.
That
So,
means that-
so in your view, does that mean it obviously isn't your view that a court never has jurisdiction over a state entity. So I guess what point do you think that does for you?
It's my view that that doesn't mean that when you see a state actor or a governmental entity, you automatically say there can be immunity defense, cases over.
Okay, but when do you think D5A applies ever then?
When
Give me a case that you think D5A precludes
there
jurisdiction.
is immunity.
But that's completely unnecessary, because that's like saying in a case where a defendant has a valid defense, the court lacks subject matter jurisdiction, and that's insane.
I'm sorry, I'm not sure.
Okay.
Can I ask a different question, then can I go back to Hess? Because when I read it, this is what I thought you were pointing to, right? So the Port Authority, the point that the court rejects there is the Port Authority doesn't return money to the state. It instead uses money for other public projects, right? That the state might somehow otherwise do, just like charities perform public projects that the state otherwise might do. But that's not a direct funding connection, right? That's that they're serving the public good, which means, like, Hess doesn't address this issue, is what I'm getting at.
May I continue?
Please.
I think that that's what my opposing counsel was saying, is they take this money and through some black box magic, they suddenly fund other roads in the state of West Virginia than the Turnpike.
Well, but the question is, does it go to DOT, right? Because I think there's a statutory provision that suggests it goes to DOT, and DOT then funds it. And if it's going to DOT, and maybe that's a factual question, I understand, but Hess wouldn't address that question.
We think Hess does because we think that the teaching of Hess is the fact that the state might benefit from the, as I
Right, but
think-
you
I
said the
think Judge
suggestion that they
Marks-
return profits, right?
Discretionary.
Hess doesn't say about returning profits. Hess says if you're otherwise doing good, that doesn't count.
I think Hess talks about discretion, American Red Cross. If it's discretionary that the agency returns money to or does benefit to the state, and the state says, if you get a judgment, we won't get that benefit, we won't get those funds, we won't get that ingenue, that's all the same. It doesn't matter because the state isn't liable on the judgment, and the fact that the judgment is rendered doesn't put the state at risk. And here, the issue isn't the authority of which entity passed this toll, passed this fee, passed this sanction. It's, was it rule made? And when we talked to Judge Haytens, when you asked that one question, I read you the language of the statute. That exemption does not apply to the Administrative Procedure Act. Therefore, we ask that you reverse the judgment of the district court and remand for further proceedings. And thank you very much for having us for my first time at the Fourth Circuit. I appreciate it.
We enjoyed the argument from both counsel. You did a fine job, and come visit us again. We're not so far away. Okay, can we go directly to our next case?
Absolutely.
We'll do that. Madison. We're ready whenever you are, but it takes a bit of time to get organized.
Good morning, Your Honors, and may it please the Court. My name is Danielle Varanian, and I represent the appellants in this matter along with my co-counsel, Gary Jones, Madison Mechanical, Inc., Madison Mechanical Contracting, LLC, Madison Mechanical OS Corp., Glenn Haslam, Gary Garofalo, Lawrence Kramer, Richard Lombardo, and Richard Arnold. Your Honors, we're here today on the appeal of an entry of summary judgment in favor of Twin City Fire Insurance Company, and as you well know, the standard of review on that appeal is de novo. The basis of Twin City's argument in its motion for summary judgment turns on the interpretation of a preposition or a prepositional phrase in the insurance policy at issue. The lower court erred in granting the summary judgment as there are numerous genuinely disputed material facts at play in this case, and accordingly we're asking this court to reverse and remand that decision. This case arises out of Twin City's denial of coverage to defend the suit brought by Mr. Bob Buczkowski against the appellants as a result of his termination from a Madison entity. Mr. Buczkowski was both an employee and a shareholder of Madison Mechanical OS Corp. When during the summer of 2015, he was informed that a new entity would be formed. He would not be a part of it. And as a result of those events, we have a cascade of events in this case. There are several key documents. First, the November 11th letter, which is a cease and desist demand letter from Mr. Buczkowski's attorneys at that time.
When you say November 11th, that's the 2015 letter?
Yes, Your Honor. November 11th, 2015, the appellants received a cease and desist demand letter from Mr. Buczkowski's attorney at that time. They promptly reported that letter to their long-term insurance broker, and then shortly thereafter, Mr. Buczkowski was terminated by letter dated November 18th of 2015. Twin City's argument in this case asks this court to look at that November 11th, 2015 letter in a vacuum. The letter itself doesn't mention Mr. Buczkowski's termination because he hadn't been terminated at the time. But when you look at that letter in the context of everything that was happening at the time and what Mr. Buczkowski knew when that letter was sent, you can clearly see that he knew he was going to be terminated. He knew he was not going to be a part of the new company. Now,
Can I ask you just, you mentioned indemnifying. So my understanding, limited, of insurance contracts is, in principle, there are two different questions here, which is whether they had a duty to defend and whether they had a duty to indemnify. And as I read the cases, in theory, sometimes the answer to those could be yes and no, or no and yes. But as I looked at your materials in this case, I don't see you as having made a separate argument. So your position, as I understand it, is there was a duty to indemnify and a duty to defend. Have you ever separately argued that even if there wasn't a duty to indemnify, there was a duty to defend? I didn't see that argument, but I wanted to give you a chance.
We have not separately argued that, Your Honor, but Your Honor, you're correct. The duty to defend is broader than the duty to.
But you have not preserved the specific argument that even if there was not a duty to indemnify, there nonetheless was a duty to defend.
We have not gotten to that because in the court below, the basis of the motion for summary judgment was that Twin City argued that coverage was not triggered at all. So there was no duty to indemnify or to defend. And the basis of that argument, I think what we have to look to is the timeline. So in any coverage litigation suit, there is a key document, and that key document is the coverage determination letter. In this case, we have two coverage determination letters. The first is from October 18th of 2016, in which Michael Knox, who is the claims representative on this case for Twin City, issued a letter stating that Twin City would provide a defense under a reservation of rights. Now, key in that letter is that Mr. Knox says multiple portions of the policy were triggered. Number one, the employment practices portion of the policy.
So I certainly understand they sent these letters that said coverage, but again, I want to just make sure the argument. In principle, when I read that in your briefing, at first I wondered if you were making some sort of estoppel argument, which is that they told us they would, and then they took that back, and I could imagine in principle that would give rise to some sort of estoppel claim. They say they defend us, and then they didn't defend us. But when I read your briefing, and then when I looked at your district court briefing, I didn't see you ever making any sort of estoppel argument, that regardless of whether they were required to say that in the first instance, they did say it, and basically no backseas. You have not made any sort of argument like that, am I right?
No.
Okay.
What we have said, Your Honor, we haven't put it in the terms of no backseas, but we
Well,
have.
or estoppel. The legal term for that is estoppel, and you haven't. I've never seen you make an argument. Again, the estoppel argument would be, look, maybe we're right, maybe we're wrong, but they said they would do this, and now they're not allowed to take that back. You've not preserved that as a separate legal argument, right?
What we have preserved is the potentiality of coverage, and what we have argued in our papers is that standard under the potentiality of coverage. And what the case law says is that if there is a potentiality of coverage, it's covered.
Right, and so you're using those letters as evidence of potentiality as a coverage, not a legal concession on their part that they're now closed from.
Correct.
Okay.
Correct. So again, though, those two letters are key, and the first of which is the October 18th of 2016 letter. After that, in that letter, it is indicated that the employment practices liability portion of the policy is primary, and then subsequent to that, on April 19th of 2017, there is another coverage determination letter from Mr. Knox in which he denies coverage altogether. The basis of the denial in that letter is a purported failure to report the November 11th, 2015 letter. Nowhere in Mr. Knox's coverage determination letter does he say that the EPL portion of the policy is not triggered. In fact, he says the opposite. And he states, in the absence of the threshold coverage issues raised above, the suit would be an employment practices claim with respect to Madison Mechanical, OS Corp., Haslam, and Garofalo. And though, to be clear, those threshold coverage issues that he was raising were the issues of prior knowledge, late notice, and lost history, not that the EPL portion of the policy wasn't triggered. Now, here, again.
Maybe I'm having a little trouble that Judge Heitens is having too, but so what, right? I mean, don't we still have to answer the question of whether this is an employment practice wrongful act? I mean, I've been waiting, but what I'm trying to figure out is, like, is it actually covered or not? I mean, we're not making an estoppel argument, and I understand maybe there's some post, entry of the agreement evidence as to how they interpret it. But the real answer is like, does it fall within the provision or does it not, regardless of what they said? They've reserved rights. There's not an estoppel argument. It's got to fall under this, wrongful dismissal, discharge, or termination of employment provision or not. And that's what first, help me understand. Isn't that fundamentally what we're trying to ask?
Yes.
Okay.
And
Can we maybe go to that
yes,
question?
And you're absolutely right, Your Honor. It does fall under that provision. So the insurance I'm sorry, Your Honor.
Well, I don't think that the judge said it did fall under that provision. He said the question is.
That's what I'm saying. His question is correct, that the real determination here is, does it fall under that provision? And the answer to that question is yes.
All right, why?
The employment practices a part of the policy has specific language in it. The Buczkowski claim triggers that part of the policy because the plain language of the policy itself states that the insurer, quote, shall pay loss on behalf of the insureds resulting from an employment practices claim first made against the insureds during the policy period or extended reporting period, if applicable, for an employment practices wrongful act. So the two questions there are, what is the definition of an employment practices claim, and what is a wrongful act?
Can we start with the latter question?
Sure. The wrongful act is defined under the policy language as involving any wrongful dismissal, discharge, or termination of employment, including constructive dismissal, discharge, or termination, wrongful failure or refusal to employ or promote, wrongful discipline or demotion, failure to grant tenure, negligent employment evaluation, or wrongful deprivation of a career opportunity. And you can find that language on page 229 of the joint appendix. The suit that was filed by Mr. Buczkowski and all of the letters that came before that suit squarely fit within these definitions.
But again, why?
So I'll take them each one at a time. First, the November 11th of 2015 letter was a cease and desist demand. The basis of that letter had everything to do with Mr. Buczkowski's knowledge of the fact that months prior to that letter being issued, he was made aware that a new company was being formed.
And he wasn't going to be hired at the new company.
He was not going to be a part of the new company. He wasn't
Right.
going to be employed any longer at Madison Mechanical OS Corp., and he would no longer be a shareholder as well. So that's a wrongful deprivation of a career opportunity. Mr. Buczkowski was also...
Wait, a wrongful deprivation of a career opportunity because he wasn't hired at a new company? What makes that wrongful?
He was... those are his allegations, Your Honor. He made the argument in the November 11th, 2015 letter to cease and desist with the formation of the new company that he would not be a part of.
Totally fair, right? And if this covered, wrongful formations of companies that is not fair, I'm totally with you there. But that's not an employment question, is it?
So Mr. Buczkowski was not just a shareholder, he was an employee, and those two things went...
An employee at will.
Yes, Your Honor, he was an employee at will. But part and parcel to his employment was his status as a shareholder. Mr. Buczkowski testified to the fact that even his compensation was tied to his status as a shareholder. He received a base salary plus a percentage of the profits. They're all inextricably interrelated.
Can I maybe just ask a more specific question and see? So it seems to me that one way of reading these provisions, the key part being the wrongful dismissal, discharge, or termination of employment, is that they're referring to torts, right? When we think about those terms, that those refer to torts, and we know are quite common employment torts that we see lots of. And the challenge here is because Mr. Buczkowski is an at-will employee, and there's no allegation that this is, race or otherwise improperly driven, right? It's not a tort, right? He hadn't been wrongfully discharged in a tort context. Why doesn't that exclude the claim that, listen, you've by doing it in the manner you did it, you messed up my shareholder rights? It is not included in the tort of wrongful termination.
Because, Your Honor, the plain language of the policy here is what controls. And the policy itself doesn't say that that has to be a tort.
Right,
What-
but we understand words, in their context, right? And in the context of talking about a suit, right, we think about the term wrongful termination and posit for a minute, maybe I'm wrong, that sort of means the tort of wrongful termination. Like that's, when you read it, that is the plain, ordinary meaning. I get maybe you think it's not, but if it's not, help me understand why it encompasses something other than the natural meaning of wrongful termination.
Well, the case law, Your Honor, says that it's not just the plain, ordinary meaning, it's the ordinary meaning that a reasonably prudent layperson would understand. Mr. Buczkowski's complaint has a count for declaratory judgment where he not only asks the court to declare that he is still an employee, but he also asks for injunctive relief with respect to his employment. Twin Cities' own...
But why, but just to understand practically what that means is he would then be employed by a company that is now defunct, right? It has no business, it's not doing anything.
Yes, but we take the plain language of what his complaint is and the four corners of that complaint on its own. And what the plain language here turns on is Mr. Buczkowski's complaint, and then further back from that, the May 10th demand letter that immediately preceded that complaint, in addition to the November 11th, 2015 letter.
I know we're about to start eating into your rebuttal time. I want to ask you about the May demand letter, though, and the language in it that worries me the most. I agree, that's the one that starts talking about his job and being wrongfully fired. But what do I do about the fact that the May 2016 letter says, I write to you in my capacity as a minority shareholder? I think that is the worst fact about that letter for you, so I would like to give you an opportunity to tell me why I should not be troubled by that.
Certainly, Your Honor. As I said earlier, Mr. Buczkowski was not just a shareholder. He also was an employee.
Oh, no, I know, but I mean, he wears two hats. He's an employee and a shareholder, and in that letter he says, I write to you in my capacity as a shareholder. Why is that not important?
I don't think that it's not important. I think that it's not the only factor that's at play here. That letter was a derivative demand in advance of his lawsuit that was both filed in his individual capacity as well as in his capacity as a shareholder. But that complaint and the derivative demand had multiple facets to it. So I don't look just to what he said in his introductory paragraph, but I also look to the substance of the letter itself, wherein he is saying in that letter, you wrongfully terminated me. You terminated me because you wanted to take my shares. You terminated me because you wanted to deprive me of this opportunity with contracting. So the letter itself has to be taken as a whole, not just that first initial paragraph. And I apologize, Your Honors, I see that I'm beyond my time. In conclusion, there's two issues when looking to a motion for summary judgment. Is the dispute genuine, and are the facts material? And in this case, we don't even agree on the determination of the basis of the denial itself and whether the portion of the policy, the EPL portion of the policy, was triggered. Those facts will change the outcome of this case, and it is a very fact-intensive analysis. And for these reasons, Your Honor, we respectfully request that this court reverse and remand. Thank you.
Thank you very much.
Good morning, Your Honors. I'm Charlie Limley of Wiley Ryan on behalf of Twin City Fire Insurance Company.
You can take the mask off during your argument if
yes,
you wish to. You need not.
Thank you. I got so used to it, forgot it was there. I don't want to regurgitate what we've written in our briefs. You've obviously read them very carefully, so if there are any questions, I'd be happy to address those. Otherwise, I would just address what we were talking about briefly.
Can you start with the idea of whether the complaint, assume everything relates back for a minute, and when I look at the letters all written together and the complaint, help me understand why I don't, how I interpret those in light of a wrongful dismissal, discharge, or termination. Can you just focus on that? I had a little discussion with your colleague about it.
Yes, Your Honor. The fact is, Mr. Buczkowski had many, many opportunities to say that I was wrongfully discharged, I was wrongfully terminated, I was wrongfully, my life as an employee was wrongfully ended. He had the November 11th, 2015 letter, didn't mention employment. He hadn't been terminated at that point. Even if you look at the May complaint, the May demand letter, he had 14 counts in his complaint, 14 opportunities to say this is a wrongful discharge case. He never did. I asked him about that at his deposition. He said, I was an at-will employee. I couldn't allege wrongful termination. What he alleged was that they wrongfully said they were terminating him for cause to trigger his obligation to sell his shares in his capacity as a shareholder. He said over and over again, and again in his deposition, that he was acting in his capacity as a shareholder. He was trying to recover the value of the business that had been taken from him. And if you look at the settlement that they entered into, that is in fact what the basis for the calculation of the settlement that was ultimately paid to Mr. Buksikowski.
So how do I understand the term wrongful termination I'll use to include all of those? I mean, there seem to be two different ways of thinking about it. One, which is, I think as you're saying it, that he didn't bring one of these 14 claims, is sort of a legalistic way of understanding that term, that, you know, we understand it as lawyers. When I think of wrongful termination, I have a certain image in mind, and it doesn't look like this. Your colleague says, no, like that's too lawyerly of you. Instead, we look at wrongful termination in sort of its much more ordinary use. And somebody would say that if you could be fired, but you were fired in the wrong manner, that's a wrongful firing. And that's the claim here, right? Is that you could fire me if you wanted to, but you can't fire me in this manner, right? That being for cause. And so that looks like, in sort of a very, layman's use of the phrase, that looks like a termination that was done for the wrong reason or the wrong manner, and that sort of looks like a wrongful termination.
I believe that the more appropriate reading of the policy is to say when it is an employment-related tort, seeking some sort of employment-related relief. The whole point.
I agree, and if it said that, that'd be great. But that's not actually what it says, right? I mean, what it says is a wrongful termination, and what she says is, yes, this was a termination. All right, we all agree with that. And was it wrongful? Yes, because it was done for cause instead of for no cause.
But I would disagree with that. He didn't say he was wrongfully terminated. He said they had the right to terminate me anytime they want to, which they did as a matter of law.
But just not for cause.
He said they gave the wrong reason in order to force him to sell his shares in his capacity as a shareholder.
That's another way that I think you could imagine this being a wrongful termination claim. They said, although I'm not sure this helps you or hurt, the real problem to me, it seems that in this case, is that his employment and his shareholder status are inextricably intertwined. And what this case is asking us to do is, how do you pull apart two things that are inextricably intertwined? Because as I understand, really the heart of his complaint to me seems, you fired me for an improper purpose, which was to squeeze me out of this company. Now, the way that's good for you is that makes his claim really sound like an oppression of a minority shareholder claim, which is apparently not covered by this policy. But you can think of it that what was wrongful about it is that you did it. Sure, you can fire me for any reason or no reason, but you did it and you characterized it this way to accomplish something that was itself wrongful, which is oppressing a minority shareholder. So what's your response to that?
Well, that doesn't make it a wrongful termination, though. That makes it a rightful termination that was used in a calculated manner to squeeze someone out of the business. This whole case is about him being squeezed out of the business. That's all he ever complained about. All of his discussion of employment is just saying, you told me you were dismissing me for cause because you wanted to force me to sell my shares into the shareholder agreement. He never said I was wrongfully terminated. He said, you had every right to terminate me at any time you wanted to, for cause or for no cause. But it was not, the point of, they said it was for cause, was to force him to sell his shares.
What do I do about the fact that the settlement agreement sure seems to characterize this as partly about a wrongful termination?
Well, the entire settlement was calculated we're in connection with coverage lawyers to get to that point. In fact, they even had him sign a declaration saying that his shares in the company had been reduced as of April of 2016, which I asked him at deposition, why did you sign that? He said, well, they told me to sign that. I understand that happened in September.
So your view that what we should say about that is that's a post hoc document that doesn't really bear on we have to write an opinion that says something. What would you propose that we say about the settlement agreement saying that it's a wrongful termination?
Well, I would say that it just is completely inconsistent with the facts, and it was a post hoc documentation that was calculated to trigger coverage under insurance policy. And the main focus there was on...
Why wouldn't that be like a disputed fact, right? So your story plausibly says, listen, like they basically signed false documents in order to try to create coverage after the fact when they had messed up on the front end or hadn't brought the right claims. all right, that seems totally plausible to me, right? But it doesn't seem like undisputed, right? Because they've sort of said the opposite, right? That it was a termination, claim.
Right, but the better reason why it doesn't matter is because coverage has to be determined at the time the claim was first made, which in this case is November 2015. So even the complaint doesn't come in. But their theory, if this thing happened, if whatever that's covered happened, if they got a claim that was covered in 2016, then it's not covered here. The court has already found that there was no coverage under the 2016 policy at all.
All right, but assume but help me understand, White, let me back up for a second. Assume for a minute that like, I think the relation back works, that sort of where you have that there shall be deemed a single claim for all purposes, right? So I think all the May stuff goes back to the November 15. That relation back provision means that I consider all of that at the time of November, right?
But not the settlement document, because that's not a claim document. They were not demanding anything in the settlement. They were just saying, here's what we're doing here. They were just, as a post hoc, just sort of articulation of their rationale for why they were doing what they were doing.
That's what I'm trying to get at. So why is that? Because what the provision says is all claims based upon or arising in any way from the same wrongful act shall be deemed a single claim. And so maybe I read the settlement agreement as saying, yeah, we're settling a claim that wasn't actually in the complaint, but we're now saying it was an employment case. And so based on this, it all relates back.
But if they're saying we're settling a claim that wasn't there, that doesn't make it a claim. A claim has to be a written demand for monetary or non-monetary relief or a complaint filed in court. The settlement document wasn't demanding anything. It was sort of a post hoc characterization of what they had done before, and it was an improper characterization. It was just wrong. The documents at most you
But
have
do you agree that if I read, hypothetically, if I read the settlement agreement as starting with a claim and then resolving it, that would, under the relation back provision, do you think that still relates back to the November 15?
No, Your Honor, because it wouldn't be a claim. If they demanded something new, then it might be a claim, but they weren't demanding anything new. They were saying, here's what we demanded a long time ago. But in order to determine coverage, you have to go look back at the time the claim was first made and say, what was the claim really? And even if you do include the May 2016 complaint, because that was a demand, and it does relate back to November 2015, the settlement document is not a claim. Claim is defined in the policy, and it doesn't include a settlement document that articulates why we're settling what we just settled. And if you look at what they actually paid in the settlement, it's pure restitution. It was based solely on the amount that they had deprived, the value of what they had taken from him wrongfully. I mean, there are multiple other reasons why there's no coverage. Even if you find it's an EPL claim, the court already found that the prior knowledge and loss history exclusions preclude coverage under 2016, and for the same reason,
But
they
the
preclude
2000
coverage under
all right.
2015.
But that argument doesn't work because the 2016 policy is a different entity. It's the LLC.
But the 2015 application is incorporated into both policies, both 2015 and 2016.
Help me understand that again.
The application was, they applied in December 2015, just a couple of
Right.
weeks after the November demand letter.
And it was signed by the LLC,
Right, but
the new entity.
it said any applicant or any individual person who's going to be covered under this policy. Does anybody have any awareness of any facts?
Yeah, but they didn't,
circumstances?
okay, all right, fine.
And by the way, it also says if there's any claims or demands that already exist, they're not covered regardless who knows about them.
They're not covered for the LLC.
No, Your Honor, it is not limited to the LLC. It says flatly, any applicant or any person who's covered under this policy.
Right, and was the old company covered, why do we think the old company was covered by the new policy, which was issued only to the LLC?
It was not, no, Your Honor, it was not. They amended the 2015 policy. They did not issue a new policy. They had requested a new policy, but they amended the policy to add the new LLC as an additional insured. The policy still, the named insureds under the policy still remained the two companies, and the individual appellants here were also insureds under the policy. All they did was add this new LLC, who they knew was just about to be sued, and it was the lead defendant in the lawsuit that they filed. They were trying to get insurance coverage that would protect them when Mr. Buczkowski got around to filing his lawsuit, and they did. And the only reason they got that is because they didn't tell anyone that they already had a demand for Mr. Buczkowski. Had they answered those questions truthfully, there's absolutely no question that the policy, even if they did amend the policy to add the LLC, that it would have been amended in a way that excluded coverage for the existing claim, the claim that already existed.
But that would only exclude it from the 16 policy, right?
Your Honor, the 2015 policy, this amendment happened in December of 2000.
Right, but the previous policy, the one that was before that, that wouldn't exclude, making a statement on that policy, but the LLC statement there wouldn't have excluded a claim that was made in November of 15, for example.
Wouldn't exclude a claim that was made in November 2015. But as of November 2015, there was no reference to any employment toward it.
I understand that argument, but what it doesn't do is it doesn't affect the question. The question is whether the November 15 claim, as related back, including the May 16 issues that are raised, falls in the provision, not about the alleged misrepresentation in the December 15 agreement.
As you just did timeline, the 2015 policy goes through May of 2016. December of 2015, they file this application, and that amends the 2015 policy going forward. It says if any claim exists as of December 29th, 2015, and you don't tell us about that, we don't deal with it right now, there will be no coverage for any such claim going forward. May 2016, they now want to make that a claim
Going
made in November
forward.
2015.
Okay, I understand your argument on that.
Thank you. And there's also, look, there's no fortuity here. Nothing fortuitous happened. There was no accident, no natural disaster that befell the appellants. They made a cold, calculated decision and implemented a cold, calculated plan to steal this man's share of the business, Mr. Buxakowski's share of the business. He didn't let them get away with it. They ultimately ended up paying him restitution for what they had taken from him. Fundamental principles of insurance law, before we even get to the policy, fundamental insurance principles like fortuity, moral hazard, all counsel against providing coverage here, or you would encourage people. This is the thing they've been talking about since the old days in the tea houses in London in the 18th century. Moral hazard. You don't want to encourage people to engage in risky behavior or untoward behavior, do things like steal business from their business colleagues, knowing that they can just get insurance if they get caught. And that's exactly what happened here, Your Honor. For all those reasons and the reasons we've articulated in our brief, we would respectfully ask the court to affirm the district court's ruling. I'd be happy to answer any more questions if there are any.
Thank you very much.
Thank you.
Thank you, Your Honors. May it please the court, Gary Jones for the appellants. I take issue with Mr. Limley, my colleague, on the last part that he addressed. This is an EPL claim that was presented. It's not a conspiracy. It's not a moral issue. I think the keys are that, number one, under the provisions that His Honor Judge Richardson was mentioning, the policy provides that all claims based or rising out of in any way related to the same wrongful act are treated as a single claim. And here you've got all these intertwined facts. And Judge Gallagher made a decision based upon a summary judgment motion that there were no disputed material facts. There are. There are disputed material facts with regard to the late notice issue. There are numerous facts with regard to the issue of whether or not this claim has the potentiality of coverage under the provisions of the EPL portion of the policy. And to get to the heart of the matter, if you look to the expert, who I believe is Michael Knox, he says in his letter, and we're not claiming no backs, but he says, based upon what he had in front of him, which included the complaint that was filed in late May, he says, with respect to the damages and other relief, plaintiff demands a declaratory judgment from the court that he remain an employee and shareholder of Madison Mechanical, along with injunctive relief ordering defendant to take all actions necessary to recognize his continued employment and ownership of shares. Further, in the same coverage letter, Mr. Knox says that because Buczkowski does allege employment-related wrongful acts against entity defendants, that they would provide a defense under a reservation of rights. They even say that because the EPL part and the D&O part are in part triggered under the policy, the loss would first be covered under the EPL part. And under the EPL part, this suit is an employment practices claim.
But I understand why you want to read the letter, but don't we have to decide that question? We don't give deference. It's in like an agency question. They're not getting any deference for us. That letter is like
Absolutely.
not.
Absolutely. It is your Honor's decision that needs to be made de novo. But my point is that even the insurance professional that was dealing with this claim at the time thought that the complaint, along with the prior letter from May of 16, stated a EPL coverage part, that there was a potentiality of coverage. And the second thing, Your Honor, when I went up
Let me ask you what I think is, for me, to the extent there was anything wrongful about his termination, it seems that it was wrongful because they were doing it to try to force him out of the company. Because if they weren't trying to do that, and he'd brought a claim under Maryland law, it seems obvious to me he would have lost instantaneously. And so do you have any authority for the proposition that under Maryland law, firing an at-will employee because you are trying to squeeze him out of a business is a wrongful termination under Maryland law?
I believe, no, Your Honor. I think there's not a case directly on point, but I think under the language of the policy, it fits squarely under the definition of employment practices wrongful act.
And I suppose maybe the answer to what I just said is, well, that indicates that if he filed such a suit, he would lose on a 12b6, but that doesn't mean it isn't a wrongful termination claim. It's a wrongful termination claim that's legally meritless under Maryland law.
And it could be either way, but we would still be entitled to.
Well, I'm not sure it can be either way. What's the authority that it can be either way and that it's not just flat out wrong?
Your Honor, I agree with that part. But if he states a claim, we have a right, tie goes to us. Knox said to me, we're providing a defense. And also, we reported that letter to Mr. Franey.
So you're going back to what seemed to be an estoppel argument, but you didn't, that isn't in your briefs. Isn't that what we talked about first time around?
Yes.
With your colleague? Yeah. But you don't, so going back to that letter doesn't do much for you, I don't think.
Fair enough. But I do believe that under this set of circumstances where you have the potentiality of coverage under the policy, at a minimum, the insurance carriers needs to provide a defense. They have not done that. It leaves the insured under this scenario, under Judge Gallagher's
So this goes back to the earlier question, I think. Tell me where the argument is, just so that I'm sure I'm following it, where you've preserved that maybe they don't have a duty to indemnify, but they do have a duty to defend, right?
I think we've preserved both. I think we've argued clearly in the papers that they have a duty to defend, and I also believe with certainty that we argued that they had a duty to indemnify. I believe that the duty to defend under Maryland law is much, much broader. If there's a potentiality that this could be covered and indemnified, they have to provide a duty of defense, which is what they said in October of 16 that they were going to do.
So your alternative relief is for us to affirm on the duty to indemnify, but reverse on the duty to defend?
Absolutely. Yes. Yes. Thank you, Your Honors.
Thank you. We appreciate your arguments, and we usually, there's no other, you're not coming back for it. We appreciate your arguments. We usually, as you know, may or may not know, we come down and shake hands afterwards, but we're not going to be able to do that today. But we do very much appreciate your arguments. Thank you.
Thank you, Your Honors.
Thank you so much, all of you.
Thank you, Your Honor.
Oh, yes, we're ready, sorry.
Good morning. Thank you, Your Honors. May it please the Court, Jenny Lyston for Nathaniel Williams. Your Honors, we're asking you to reverse the order of civil commitment here because Nathaniel Williams does not meet the statutory criteria for civil commitment under 18 U.S.C. Section 4246D. That section permits commitment only where there is clear and convincing evidence that, quote, the person is presently suffering from a mental disease or defect, as a result of which his release would create a substantial risk of bodily injury to another person or serious damage to property of another. Your Honors, here the undisputed evidence showed that Mr. Williams was diagnosed with schizoaffective disorder. However, by the time of the hearing, both experts agreed that he was in remission. He was stable and symptom-free, and that was because after years of trial and error, he had finally found a medication that worked extremely well for him, one that he enjoyed taking and that allowed him to live a normal life, and that was the monthly injectable form of Haldol.
Can you talk about, just as a factual question, can you start talking about, when I look at J126 in the report, after he's owned the shots of Haldol, he reports that he does not have a mental illness and that he did not require medication all the time, but instead only as needed, right? So this is after he's owned the injection, and he reports to the provider that I don't require medication all the time. And I understand once he gets to trial, once he gets this proceeding, he says, no, I like this, I'll keep doing it. But it seems like in looking for substantial evidence in the record, that's a really hard thing for me to get my head around in the context of your argument, because he's basically admitting, I don't really need to keep doing this, right? I'll just stop when I want to because I'm not really sick.
So I think that interview takes place pretty early after he has been on the Haldol, Your Honor. Certainly, you're right. By the time we get to the hearing where he testifies in person, he openly acknowledges, absolutely, I do have a serious illness here. Both experts agreed, though, he enjoyed taking the Haldol. It was working well, right? Also, the fact...
He took medicines before. What I'm trying to look at, though, right, because given the standard that we've got in reviewing the trial judge's decision, that seems like really hard evidence for you. And so I take it you're saying one thing is, oh, well, maybe that statement was early on in the Haldol, and the buildup of Haldol, changed his views. The problem is there's nothing in the record. I don't know of anything that actually supports that, surmise. Is there anything else that you want to say about that particular provision on 176 where he says, I'm on Haldol, but I'm not really sick, and I just need medicine whenever I need it, not all the time?
So I think what this turns on, Your Honor, is that the district court finds that Mr. Williams' dangerousness is contingent on his medication compliance, right? But then goes on and makes no findings on the likelihood of...
I understand that argument, and maybe the answer is no, and that's totally fine. But is there any other context or anything else you want to tell me about his statement after his own Haldol that I don't have a mental illness and I just need medicine when I need it, but not all the time? No, okay, that's fine. I wasn't trying to be difficult. This isn't a trick question. I just want to make sure I understood the context for that statement.
Your whole answer is that they are separated in time. Do you know, can you tell us, maybe when you sit down, you can get back up and say, that was said X and this is said Y, because that is your whole argument, right? With respect to that.
Right, we're talking about, this is a period of 8 months later, 8 months during which he is completely stable and symptom-free, right? So the district court makes a finding that Mr. Williams' dangerousness is contingent on his medication compliance, but then makes no findings to say that Mr. Williams will not comply with his medication going forward. And in fact, we know that for at least 3 years, he's absolutely going to have to comply because he is on a term of supervised release.
So why is that, right? Because he's been on other supervised release, and maybe you say the state's not as good as the feds on supervised release, but he's been on other supervised release and is not a model of compliance.
when he was on different medications that show that were not very effective for him, right? So he's now on an injectable form of Haldol. Importantly, this is not self-administered, right, Your Honor? He has to be given this.
He has to show up, though, right?
He has to show up for this injection. There is no scenario under which Mr. Williams doesn't show up for his monthly injection of Haldol that probation is not going to know about it, right? That is an easy phone call.
How is probation going to know about it?
Because the medical provider.
Would call probation?
Absolutely, absolutely. On the terms of his supervised release, absolutely. They're going to be, and presumably it's either going to be with the ACT community support team that could come to his house as often as need be, but absolutely his medical provider will be in communication. The probation officer is going to be in communication with the medical provider.
Well,
Is Mr.
Do we really, I mean, so as a practical matter, I guess, how do we know that, right? Because oftentimes, probation officers have a really hard job, and they're not quick, I think, as a general matter, to yank somebody off or report their supervised release violation for the first infraction or the first time that something doesn't go exactly right. And so, I don't know much about the probation officers in Portland or the relationship. How do we know that he would immediately be, reincarcerated if he failed to show up to get his shot?
Well, let's say this. The district court says that if I could impose conditions here, then he's, the district court was comfortable. It wanted to impose conditions, but understood that it couldn't impose conditions unless it first committed him. There's nothing special or magical about the commitment court's ability to impose conditions here. They're going to be under the exact same type of conditions.
And he could require there be immediate arrest. If he fails to show up for his shot, he must be immediately taken into custody. A fact that he does not know about whether that would happen under the supervised release conditions, even for the 2 years that he's got on, even assuming the 2 years was the only question we had.
I've never seen a conditional release plan like that, Your Honor, that says if he doesn't show up for the shot, he shall be immediately arrested. In general, conditional release plans look exactly like the conditions that are already in place for Mr. Williams.
You mentioned the district court. I'd like to ask you something about the district court said at the end of the hearing that I'm going to ask both of you about. So at the end of this hearing, the district court says, I'm going to order him committed, but I expect there to be a conditional release plan proposed in the near term. What is the status of that?
There is none that I know of at the time, Your Honor, exactly because of this appeal. So there's
Wait, I don't see why this appeal would have prevented someone from proposing a conditional release plan in the last X amount of time.
Would it make your claim moot if he
No,
got a
no.
conditional release?
Absolutely not, because
Why not?
we're arguing here about the district court's initial commitment of Nathaniel Williams, not the ability to later on perhaps put
Take back some of it or lift some of the restrictions.
Right. So again, the district court makes this finding. It's contingent on his medication compliance. There's just simply no evidence to show that Mr. Williams is not going to be compliant with his medication regime. Again, both experts agreed he took the medication willingly, he enjoyed the medication, and he is required to take it as a part of that supervised release term. And I would just like to note that there's some debate over here about how long the supervised release term is in effect. Even assuming that the Turner rule is in effect and, he would not be judicially estopped. I mean, we're talking about a supervised release term that doesn't expire until mid-December of 2024. So even
What about
today.
if a district court, just hypothetically, right? And I understand you don't think this is the story, but imagine a district court said, listen, I have a fair degree of confidence that for the next 2 years, he is going to comply. But I also am confident that the moment he's off of supervised release, that he is going to stop taking his medication and has an extremely high likelihood of committing violent crime if that were to happen. Hypothetical, not your case. I'm not trying to get you to agree with the hypothetical, right? The district court could plainly do that, right? And say, there's not a risk for the next 2 years, but there's a risk in year 3 that is substantial, that I think is clear and convincing, and so I'm going to order him detained, even though the next 2 years, he's going to be okay.
No, I absolutely.
Help me understand
disagree with
why
that.
not.
I did, because the problem that Congress is trying to solve here, right? The problem that we're looking at is this very unique problem of the federal government being in control of people who are incompetent people whose release may pose a risk, right? And I would urge the court to look at United States versus Comstock. There's a very interesting discussion.
No, it will.
There's an interesting discussion in there about the court analogizes this situation, this sort of narrow exception to tort liability. And so when you assume custody over a person, you then have a corresponding duty to the public, other persons, to prevent harm from that would be posed by this person. And it talks about, hypothetically, if someone with an infectious disease. When you're talking about a risk of harm that doesn't arise until 2 years or 3 years after someone has been released, I mean, that tort liability is extinguished there, right? There's no duty, continuing duty to protect the public because you're, for years and years in advance. I think that's actually.
Where do I get that out of the statute? Help me understand how all right, so that's an interesting sort of like policy argument, right? But what I'm trying to see is like the statute doesn't say a substantial risk within the next 2 years, right? Or substantial risk of great bodily harm within the next 8 months.
True, but Congress has written this statute with Supreme Court precedent in mind. Decisions like, Jackson v. Indiana and the idea that it is a due process violation to keep an incompetent person committed unless they pose a danger, right? I think you're running perilously close to a due process violation when you're talking about not a substantial risk. The statute talks about a substantial risk.
All right, but we don't have a due process claim here, right? Like your claim is not under the due process clause. Here's the statute, was it satisfied?
Correct.
And maybe at some point, maybe there would be a due process claim, but like not here.
Our understanding of the statute is it's talking about substantial risk. The substantial risk has to arise as a result of the person presently suffering from the mental disease or defect. So we think what Judge Britt did here was he did not base this commitment on substantial risk, but based it only on sort of this contingent future possibility of danger.
So
right?
I know that you definitely don't think the district court, so I definitely understand that you're making a failure to explain, but I want to see if I think you're also making a substantive. So I agree the district court didn't say this, but I want you to imagine the district court had hypothetically said this. Look, the real problem here is I don't know. I guess I know that in the past, when released while on other medications, this individual did not comply. I know that. I think the district court said first, here's what I know. When he's medicated, he's not dangerous. When he is not medicated, he is dangerous. I know, so then this case really comes down to how likely is he to take his medication. I know that in the past when he was on release with other medications, he did not, but those were different medications and those were in the past. I know that he's currently taking his medication voluntarily, but he's doing that in a custodial setting where candidly he is aware that if he does not take it voluntarily, he will be forced to take it. He doesn't really have a choice in his current environment, even when he takes it voluntarily. So my real answer is I don't know. The honest answer is if I release this man, will he keep taking his medication? I don't know, and I don't know how it's possible to know under the current situation. If the district court had said that, would that have violated the statute?
Yes, Your Honor. Yes.
Okay.
And especially when he's disregarding and discounting the supervised release conditions that are in place. He's ignoring the facts on the ground. And the reality is that Mr. Williams is going to be under intense supervision for we contend 3 years, but possibly 2.5. And that under all of those conditions, there is simply no way that Mr. Williams, one, is going to discontinue his medication, but two, if he does, people are instantly going to know about it. And he will, if he violates any term of his condition, he's subject to reincarceration. And of course, once he's,
Didn't the district court suggest, right or wrong, that he didn't believe that Oregon was going to do that? That he would instantly be notified and the problem remedied? I mean, he seemed to call into question whether Oregon would actually do that, right?
well, I believe what he said, Your Honor, was that, I don't know how much of this term has expired, and I don't know of any way that it can be extended. He also said that, I'm not sure that the court there in district really has your best interests in mind, and the safety of the public in mind. And of course, as we've argued strenuously in our brief, that's absolutely not true. The district court in Oregon was absolutely concerned with Mr. Williams' mental health and the safety of the public, and that's why it puts so many special conditions in place, directly addressing those issues. So, and again, Mr. Williams is going to be in Oregon. So if there's anyone who is going to be concerned about the safety of the public, it's going to be the Oregon court, not the court in North Carolina.
Well, shouldn't the court in North Carolina have taken more account of the Oregon court?
I do think the Oregon court would not be super happy with the court in North Carolina suggesting that it didn't have Mr. Williams and the public's best interest in mind. I do agree with that.
No, I don't mean.
I'm so sorry, Your
Honor. Rude. What I mean was, should the district court have looked at what the Oregon court did, what its result was, and assessed that in making its assessment?
Absolutely. I think it should have done that, Your Honor, but it did not.
Do you happen to know off the top of your head what page the supervised release conditions are on in the JA?
Yes, Your Honor, those are on.
Sorry.
You know what, and I meant to have it right there, but that is on JA 128.
Thank you, ma'am.
Yes, sir. I see my time has expired. I will be saving the rest of my time for rebuttal. Thank you.
Thank you. Go ahead, Ms. Petrie.
Good morning, Your Honors. Jenna Petrie for the United States of America, and may it please the court. The district court did not err on the facts in this case in finding that Nathaniel Williams met criteria for commitment as a mentally ill and dangerous person. We've heard a lot of conversation about the particularized facts in this case, and speaking specifically to some of those facts, there was no dispute in the record that Mr. Williams suffered from a mental disease or defect. Both evaluators diagnosed him. One put him in partial remission, the other in full remission. But the fact remains that he was diagnosed with schizoaffective disorder, bipolar type, at the time of his commitment hearing.
Ms. Petrie, can I ask you about that? I tried to find authority on this, and I couldn't. The parties don't seem to disagree. It says presently suffering from. So that leads to be the question is a fully controlled condition a person? So the statute doesn't say, does he have schizoaffective disorder? It says presently suffering from. And it wasn't immediately obvious to me that a person whose condition is currently controlled is presently suffering from. Do you have any authority that helps? Again, the parties don't seem to disagree about this, but when I saw that, I was immediately not sure about the controlled condition person.
No, Your Honor. To the best of my knowledge, this has never been raised by this court or any other circuit court that I've been able to locate, this issue of what presently suffering means. Now, of course, the government would offer that presently suffering means having an active diagnosis, which Mr. Williams does in this matter. He has an active diagnosis. Whether it's in partial remission or in full remission, I think is a factual dispute in the record whether or not he continued to suffer from auditory hallucinations. Our position would be that he did, that the evidence shows that he did continue to suffer from those.
So can I bring you back to something that both of my colleagues mentioned at the end of the previous argument? I mean, I mean this advisedly, as a former government litigator. I was literally flabbergasted when I read what the district court said about the District of Oregon. So is of limited duration, well, that's fine. And then the district court says this, is subject to the control of some other court that does not have both your best interest and the mental health of you and others, and the safety to the public. I mean, I mean this sincerely. I was flabbergasted when I read that a federal district court had said that about another federal district court. Why is that not legal error all by itself? To the extent the district court suggests I am not doing this because I do not trust the United States District Court of the District of Oregon to treat you appropriately. Why is that not legal error all by itself?
I'll agree, Your Honor, that could have been better worded, but I think when we look at this.
Don't we also include, when he's talking about the court, so I read, maybe I was less flabbergasted, but when I read that, I interpreted the court there to include the probation officer, which works for the court, right? And in that sense, it's expressing some concerns about whether the court as a whole was going to live up to the conditions that are put, because it recognizes that there's invariably wiggle room in the violation of supervised release conditions.
I read it as being that this isn't a court that's familiar with this kind of, not criminal commitment, but, that got a separate category of, yes, you're endangering people, and so you're committed, but it's only a civil commitment. I mean, this facility that is in North Carolina is, I think people from all over the country come to.
I would agree with you, Judge Motz. That was also the government's interpretation of what the lower court was trying to
But I think
iterate.
it's entirely possible that it means whatever that means.
And
That Portland is some lawless enclave where we
Right.
just let people go for no reason at all.
Well, and I think
And many people think that.
important distinction here, when we're looking at what the two
Can we
courts.
quote that, by the way?
I think the important distinction when we're looking at what the two different courts did is that the District of Oregon was imposing criminal supervision. But what the lower court here, the Eastern District of North Carolina, is talking about, as Judge Motz aptly pointed out, is something so specific. We are here for the distinct purpose of Mr. Williams' mental health. And so it's not necessarily saying, I don't trust the District of Oregon to revoke, or I don't trust probation to do this, but that I, as the civil commitment court who understands mental health, who's worked on these cases for a long degree of time and who see these come and go, I know what conditions a person who has a mental illness and who needs to be protected and the public needs to be protected, what conditions to impose. And while
And I agree the district court said that, and the judge also said something at the end of the hearing, which is, government, I'm going to give you your commitment. I expect a conditional release plan, like forthwith. Have you done that?
Your Honor, so this information is not contained in the record, so that it's not before us in the record. However, there were efforts made outside of what's before Your Honors in this record to create a plan to conditionally release Mr. Williams. As I believe you'll see in the record, the Respondents' Council had proposed a plan that Mr. Williams go and live with his sister. So that plan was further investigated. Again, not in the record, but there were concerns that Mr. Williams did not desire to
But I guess we certainly can take judicial notice of anything that happened in the district court. What the district court judge said, I expect you to present me, the district court, with a conditional release plan, because if you present me with one, I will approve it. Has the government done that?
The government has not done that at this time.
And how long has it been?
It has been since April 12th, I believe, Your Honor.
Of this year?
Of this year, Your Honor. And so
But you can only submit a plan that the defendant agrees to, right? I mean,
well,
you can't force him to live somewhere that he says he will not live.
we can't force him to live somewhere that he will not live. And the issue kind of remains, I think, in this case is whether this would be a conditional release consistent with 4246E, or if this would fall more under either 4246D2 or perhaps even a review hearing under 4247H, and that issue being whether or not the warden would need to certify that the person was appropriate for release. And so further investigation by the evaluator in this case might be needed in order for the warden to come to that determination.
Is there any reason, your colleague suggested that the reason there's no plan is because of this appeal. Is there any reason from the government's perspective to believe that resolving this appeal would encourage or move forward a plan?
I certainly believe that the resolution of this appeal, of course, in favor of the government, would move that plan forward. I think I agree with my colleague in saying that this appeal somewhat stayed what was happening in the lower court, because of course, if this court finds that Mr. Williams was not appropriately committed and that clear error was committed, we would either need to be remanded back to another hearing to determine whether or not he meets criteria for commitment, legal issues aside, or he would be released on his 2 years of remaining supervision, and thus a conditional release plan would no longer be necessary in this case. I think one of the important factors when we're considering Mr. Williams' mental health condition is that we don't just have to look at it in a vacuum, what was presented at the hearing. And in fact, this court, in an unpublished opinion, but referencing the United States versus Williams from the 8th Circuit, talked about how we have to look at the person's entire symptom profile, not just the most recent manifestation at the hearing. And so we shouldn't just look at how Mr. Williams was doing at the hearing, but we need to look historically how Mr. Williams has been doing in the past. And I think that this is also one of the most important things when we consider the supervised release conditions as well, is because so much happened just between the time that those supervised release conditions were imposed by the District of Oregon in December of 2018 and when Mr. Williams became before the court in April of this year. I mean, we're talking about 36 incident reports, a 4245 commitment for hospitalization of a mentally ill person who's sentenced, and then the involuntary commitment order, or the involuntary hospitalization order for him to receive care and treatment. And so there's so much more evidence in the record, and we can't just look at this one data point.
Can I ask you the question that I tried to follow up with your colleague? The district court seems to say, with respect to the supervised release condition, effectively there are two reasons why those conditions don't matter. One is the limited duration, and then the other is the musings on the District of Oregon court. Talking about the first one, would that be like a sufficient ground? So imagine we thought that the second was a problem. So we decided the District of Oregon was for some reason improper. Would the limited duration be sufficient? So in other words, if the court determined that going to be great for 2 years, but as soon as they're all supervised release, there's going to be a substantial risk, is that enough under the statute?
I think it is enough, Your Honor, and that's because what Congress created 4246 to look at, and you'll notice it's not the word imminence, because imminence doesn't exist anywhere in the statutory scheme. So we're not looking at the right now. We're trying to predict risk, and in fact, this court has echoed the sentiments of other courts when we talk about this issue. We're looking at trying to determine a person's behavior and whether it evinces a genuine possibility of future harm. And so when we're talking, we have to be talking about future harm, and we have to be talking about predicting risk, because this is imprecise. We don't know exactly that, for 2 years he'll be great, but in that 3rd year he's going to really struggle. We have no idea. And that's why we have to look at this whole record. We have to look at every little piece of information that we have.
Well, then can I ask you then, because you say this in your brief a lot too, but I just see a significant tension. I pulled this up on page 51 where you say, we have to look at the whole record, except the district court is actually not required to consider supervised release. And would you help me see why there is not a tension between saying, look, the district court can't look at pieces of evidence in isolation, we have to look at the whole scope of it, except then on page 51 of your brief, you said the district court is allowed to completely disregard the entire existence of the supervised release. How is that possibly true?
Well, I apologize, Your Honor, if it came across that way. I certainly don't mean to imply that the district court should ignore any piece of evidence in this case. And in fact, I think Dr. Muckin, the government's evaluator, really talks about all of the evidence, the protective and the risk factors. What I mean to say is that there are really 3 criteria that we have to look at when we talk about whether or not a person should be committed under 4246. It's their mental condition, whether that creates a substantial risk of dangerousness, and whether state placement is available. Those are the 3 things that we know that the court has to look at. But as this court held in United States versus Cox and United States versus Ecker, we have to look again at that totality, and we have to look at the things that evaluators typically look at. And one of those things in this case was the supervised release. But nothing in the statutory scheme requires us to take that into full consideration or give it more weight than any other factor. And so I don't think the fact that he has 3 years or perhaps now 2 years of supervised release, according to the Ninth Circuit, should be the most important factor in this case. And in fact, this court in other cases, specifically in United States versus Bell, a 4248 commitment, affirmed a person's commitment when he had lifetime supervision. And so this one factor can't be the factor that we hang our hat on.
Is it different when we talk about considering supervised release? Is it different than considering like the conditions in which someone being released would live. So we often think about district courts saying, listen, we think he can be released because he has a stable home to go to, his parents are happy to have him, that's a place that he's comfortable, right? That's something that might reduce the risk. And you might think that supervised release of a limited duration might reduce the risk for that in this sort of a similar manner. Is that the type of analysis we're looking at?
I think it's certainly possible to make that analysis, but what I would posit to this court is that when we're talking about a conditional release, or if we're just talking about the risk factors that the two evaluators in this case considered, they are looking at where is he going to go, where is he going to live, what family support does he have, and what things are available to him that we can ensure that he has success. And not to compare and contrast too greatly the supervised release to a conditional release or the supervised release to his risk factors, but we look at those things and there were so many unknowns. My colleague talked about an ACT team, an assertive community treatment team being possible, but we see in the records that one isn't actually set up for him. It's actually not included in the supervised release. And so how do we ensure that a person who has such a troubled history, who is a very young man still, but who has such this troubled history of acting out aggressively towards family, towards indiscriminate others, strangers on the street, in such a violent manner, and then proceeding that violence and continuing that violence into the structured environment of the Bureau of Prisons, and racking up 36 incident reports between, I believe, May of 2019 and May of 2021, this is an incredibly short period of time to just do so much. And so, no, I don't think it's a compare and contrast, and I don't think it's necessarily that one is better in the long term than the other, but Mr. Williams only has 2 years left of supervised release. And it's simply, as the court said, it's not the duration or the ability or the focus that Mr. Williams really needs to be successful in this case. As I mentioned, I think we need to look at the entire behavioral and psychiatric profile of Mr. Williams. I think when you do that, when you consider all of the evidence, the ongoing auditory hallucinations, the mental health treatment, the commitment order, the involuntary nature of his medication, and the fact that there's certainly no guarantee that he would continue that medication in the community, whether he's supervised by probation or not, and the substance abuse, the fact that he's never received substance abuse treatment, his weapons use, and just his history of acting aggressively when psychotic, I think all of this evidence supports the final conclusion of the district court in this case. And so unless the court has any other questions, I would rest on the government's brief and ask that this court affirm the findings of the district court. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. Judge Heitens, I wanted to come back to a couple of questions that you posed to my friend on the other side. First was this idea that the government argued at the hearing, and the court puts into its order at JA 161 that you shouldn't think about the supervised release terms at all. They simply shouldn't be factored into this consideration, and it's unclear. Part of the court's order that troubles me is that it is unclear from the court's order whether it felt that it was just going to discount these supervised release terms altogether because it felt like it had to evaluate this in a vacuum and not consider those, or whether or not the court felt like those terms were not going to be sufficient. And so I do think that's a troubling aspect. I want to emphasize again, a conditional release plan, the commitment court in North Carolina actually has less ability and less authority than the district court in Oregon to tailor conditions for Mr. Williams, because its authority is restricted to placing Mr. Williams on a prescribed treatment regimen, right? Those are that kind of conditions that the commitment court can impose. The district court in Oregon, on the other hand, can impose and modify any condition on Mr. Williams. So again, we think the district court in Oregon was far better suited to come up with any sort of conditions that Mr. Williams needed, and in fact did. And again, we were already working with the public defender in Oregon. Mr. Williams already has a probation officer in Oregon who is well aware of the situation and can take every precaution necessary to ensure that his release does not pose a risk. And again, when we're talking about, I think there's what is so dangerous about this opinion and why it's dangerous to affirm this is this idea that we're, instead of basing commitment on substantial risk based on the person's present suffering from his mental illness, we are going to instead base it on contingent future risk only. We just don't think that that is what
Isn't substantial, I mean, in the very definition in the statute, a contingent future risk, right? I mean, that very point of substantial risk, I mean, risk is about contingent possibility, right? We're not saying, I mean, presumably, like, if in the courtroom he beat up the bailiff, right, that would be probably pretty good evidence, but it would only be evidence that he would do it next time. Even that beating up the bailiff in the courtroom during the hearing would be relevant because it tells us something about the risk of release, which is the future possibility.
And I don't disagree with you, Judge Richardson. There is some future, obviously it has to be
It's only
to a
future.
certain degree, right? Because
Only future.
the release hasn't happened yet, right?
Right.
So obviously we're talking about the future. But how far into the future are we talking about? And one of the reasons I submitted the 28J letter with the North Carolina opinion, I just thought it was interesting that, you know, if they definitely limit it to within the near future, right? Because again, if Mr. Williams
Totally fair, but write your congressman, right? I mean, that might be a really good idea to say, is it a substantial risk within the next 5 years or 2 years or 1 year?
So I think if we're talking about risk that far out, then we are moving away from 4246D's language that the substantial risk has to arise from the present suffering. And Judge Heidens, I would also note that I do think it is interesting that whether or not someone is said to be presently suffering, we do agree that we believe that you have to have active symptoms, and our trial attorney argued that quite a few times. But I will also agree with my colleague, there is simply no case law on that particular aspect. And we believe that it more goes to the substantial risk has to be tied to the presently suffering. I think if the person is at the initial commitment, if that person is already recovered from their mental illness to such an extent that the district court is talking about conditional release, I don't think they qualify for initial commitment, right? Because 4246D doesn't talk about conditional release at all, right? That's only after initial commitment. So I think the trial court sort of erred here in jumping the gun and looking ahead and not focusing on the statutory criteria for initial commitment under 4246D, but instead sort of leaped ahead and was looking to D1 and D2 and to revocation proceedings. I see that I'm out of my time. Your Honors, if there are no further questions, we respectfully request that this court reverse the order of commitment. Thank you, Your Honors.
Thanks very much. We appreciate your argument. As we probably both know, we usually come down and greet counsel, but we can't do that this time. But we do appreciate your argument. I'll ask the clerk to adjourn court.